Very well. Thank you, Mr. Baumgartner. I want to ask you all to turn off your cell phones if you're certainly using them to log in, but certainly keep the volumes down and please keep talking to a minimum. Obviously, things are being recorded as per the authority we have to record them in this manner. The board will vote on each case and make a decision at the end of the docket. You can stay logged on to hear those deliberations as we would if we were live. Otherwise, you can call the BMDA office tomorrow morning after 9 a.m. The number is 410-396-4301. And that's 410-396-4301. You should receive your resolution in the mail within 30 days. Please do not do any work until your resolution is in fact received. And of course, do not do any work in Baltimore City without pulling the proper permits. There, as Mr. Baumgartner spoke, there are some postponements today. I will again go through that list. If your case is postponed, please call the office at that number that I mentioned. Reschedule your case. Of course, if you were signed into some opposition or on the line for some opposition to those postponed cases, again, please follow up with the BMDA office to confirm when that matter will be set in again. Postponed cases are as follows. Case number 2020-56, 712 Winston Avenue. Case number 2020-68, 533 through 535 North Belnord Avenue. Case number 2020-69, 2214 Canary Street. Case number 2020-70, 1436 Albert Street. Case number 2020-78, 5721 Pimlico Road. And those are the postponed. Oh, I'm sorry. I also have a withdrawn case, which is in the same category for all intents and purposes, is postponing. Case number 2020-83, 246 South Conklin Street. Also not being heard. For those who are signed in for opposition, obviously there's a way we would situate you if we were live, but just know that Mr. Baumgartner will be handling, I guess the unmuting of you to allow you to be heard. We will have the applicant testify as to his or her case with whatever witnesses are present. Then the opposition will be able to respond. We ask for both the applicant and the opposition that you not repeat particular issues or points. We're well able to take that information in, and it also bogs down the time that we have to conduct this proceeding. The applicant will have the final word. You will all, I believe, be sworn in at one time. So when you are given the green light to testify, understand that you are testifying under oath, and we will take it in that regard. But again, we will deliberate on those cases at the end of the proceedings. At this point, I will call the cases for which the board has concluded that we have sufficient information to grant your request. Those are the consent cases. I will call the case number, at least identify all those case numbers, and then I guess I have to do it one at a time now since we have the list. Well, I'll do them all at the same time. All the consent cases are as follows. Case number 2020-66, 3530 Buena Vista Avenue. Case number 2020-74, 1001 North Broadway Street. I'm sorry, North Broadway. Case number 2020-
Looks like Mr. Fields dropped out. Did everyone get that?
Spinning on my screen.
Yes.
Yeah. Looks like there's a bandwidth issue with Chairman Fields. Chairman Fields, you're back, and you're frozen again.
Oh no.
So let's give this just a minute or two to see if we can get Mr. Fields back here. And for the chat feature, that's correct. Chairman Fields, there's a bandwidth issue on the platform, so he doesn't have access right now and does not have audio. So James, if you can hear me, let's try logging off and logging back on again. And I'll go through the rest of the consent cases.
I think he's back.
Yeah, I can
Might
hear
be back.
you, Derek.
Okay. Let's see if you can log off and log back on again. You kind of dipped out again. I can finish the consent cases, and then we can move on to the regular docket, if that's all right with you.
That's fine. Go ahead and get started. I'll catch up when I am able to hear you all and see you all.
Okay, great. So for the record, I'll just go back over the consent cases. We have 2020-66, 3530 Buena Vista Avenue, Ian Sokolowski. To construct two-story dwelling detached with rear parking pad. We have 2020-74, 1001 North Broadway. The applicant is Wally Smith. He used the first floor as a clothing store. 2020-81, 2700 Dillon Street. The applicant is Dave Schilling to construct a second floor rear deck and rooftop deck. We have 2020-82, 1248 William Street, Roger Shiflett to demolish and reconstruct existing second floor rear deck. 2020-85, 554 East Ford Avenue. The applicant is Todd Marks to install a 15.7 square foot double-faced 28-inch projecting corner sign. And we have 2020-89, 1106 Riverside Avenue. Applicant is Chris Casey. 2020-90, 1511 William Street. The applicant is Matt Nopeful. 2020-91, 715 South Conkling Street. The applicant is Matt Nopeful. And then 2020-92, 3918 Falstaff Road. The applicant is Donnie Ankry. For consent cases, we will ask if each of those applicants has anything to add to the record. If you do not, you certainly do not need to add anything to the record, but we'll go through those one by one now, very briefly. First case we have on consent is 2020-66, 3530 Buena Vista Avenue. Mr. Sokolowski, I did see you here. I am going to attempt to unmute you. So there you are. All right, give it a minute, or I'm sorry, give it a second or two, and you should be unmuted and have video access if you have a video feature to be able to testify. Mr. Sokolowski?
Yes. Can you hear me?
Yes, the floor is yours. If you have anything to add, sir.
No, we do not. The case is as described in the zoning application, so nothing further to add on that.
Great. Thank you very much.
Thank you, sir.
The board, having reviewed your case, finds sufficient information on the record to approve your appeal.
Thank you very much.
Thank you.
Derek, can you hear me now? Never mind.
Yes, we can, sir.
I think I'm up and running.
Great. So I did the first consent case. We're on to the second consent case.
So calling the case of 2020-74, 1001 North Broadway Street, Wally Smith, used first floor as a clothing store.
Let me see if I can find Mr. Smith. Mr. Smith, are you on the phone? Mr. Smith. So I'm trying to see if Mr. Smith is on the line. Go to the chat feature right now. I don't see anyone that's, aha, there he is. Mr. Smith sent a message, but I don't see him on the list. So I'm not sure what happened with that.
Should we?
So let's go on to the next case, Mr. Chairman, and we can see if we can get Mr. Smith back.
Very well. I'm calling the case of 2020-81, 2700 Dillon Street, Dave Chilling, to construct second floor rear deck and rooftop deck.
Let's see if we have Mr. Chilling. There's Mr. Schilling. Mr. Schilling, I am making you a panelist, so just give it a second or two and you should be able to speak. Mr. Schilling, are you there?
Oh.
Yes, sir. We have your case as 2020-81 to construct second floor rear and rooftop deck. Was there anything else that you would like to add to the record?
No, sir. Nothing further to add.
All right.
Well,
Okay.
the board having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you, sir.
Thank you.
Moving on to case number 2020-82, 1248 William Street, Roger Shiflett. It's for demolition and to reconstruct the second floor rear deck.
Mr. Shiflett, you should be live right now. Mr. Shiflett? Mr. Shiflett?
Yes, I'm here.
All right, Mr. Shiflett, this is a request to, go demolition and reconstruct the existing second floor rear deck. Is that correct?
Yes, sir.
Is there anything else you'd like to add to your application at this time, sir?
No, sir.
Okay. Well, the board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you.
Thank you, board.
Thank you.
Mr. Baumgartner, one point of order. Should I be requesting staff reports again on the consent matters as we normally do?
Yes. Yes.
For the
matters that have gone forward so far?
For the record, the planning department has no comment on any of these consent appeals except for number 74, where we are recommending approval. However, you have not been able to hear number 74 because you haven't been able to make contact with the applicant.
That's all right. Very well. That's helpful for the rest of the document. Okay. We'll move on to next consent case, 2020-85, 554 East Ford Avenue, Todd Marks. Request to install 15.7 square feet, double face, 28-inch projecting corner sign.
And Mr. Marks, you should be live now.
Mr. Marks, are you present? Can you hear me?
Mr. Marks, are you there? I hear noise, which is a good thing.
Here we go. He's muted, it looks like.
All right. Mr. Marks, are you there?
Yeah, he's here. I've got him audio, and he's unmuted, but I can't hear him.
If there's a connection problem.
Let's
Let me just check the chat feature real quick to make sure he's not reaching out via the chat feature. I don't see anything here. Let's do one quick thing just to make sure. Mr. Marks, are you there? Mr. Chairman, we do have this on the consent agenda.
Yep.
And there's no test. We have not received any evidence in support or in opposition to this appeal. So the board can certainly proceed without any further comment from Mr. Marks. And if there's something he would like to add, he can certainly reach out after the hearing.
Very well. So for the record, the board having heard the appeal for 2020-85, we have sufficient information to approve the appeal for 554 East Ford Avenue. Okay. Move on to the next consent matter. Case number 2020-89, 1106 Riverside Avenue, Chris Carey, to add a rear addition and enclose an existing porch.
And I did see Mr. Carey here. I am unmuting him now. So just give it a second or two. Mr. Carey, are you there?
Can you hear me?
Yes, sir.
I want to thank you for the approval. Board, appreciate you. Stay safe, everybody.
All right, Mr. Carey, is there anything else you'd like to add to your application at this time?
No, thank you.
All right, well, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you, sir.
Thank you.
Have a great day.
Be safe.
Calling the case of 2020-90, 1511 William Street, Matt Knopfel, to construct first and second floor rear additions and rooftop deck.
I found Mr. Noteful. I am unmuting him now. Just give it a second or two.
Sure.
Mr. Noteful?
Yes.
Good afternoon, Mr. Knopfel. Is there anything you'd like to add to your application for 1511 William Street at this time?
No, there is not.
Very well. Well, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Great. And while I have you, we'll call again the next case, 2020-91, 715 South Darkling Street. Again, that's you, Mr. Knopfel. Again, to construct a detached garage, first and second floor rear additions, and a rooftop deck. Is there anything you'd like to add to your application at this time?
No, there's not.
Very well. The board having heard your appeal for case number 2020-91, we believe we have sufficient information to approve your appeal. Thank you, sir.
Thank you.
Right. Moving on to case number 2020-92, 3918 Falstaff Road, Donnie Ankry, to construct a one-story rear addition.
All right. Mr. Ankry is on the line. I am trying to find him. I believe. Mr. Ankry, are you there? Let me check. He had sent a chat feature about accessing the phone. Mr. Ankry, what is your phone number? That way, or at least the phone number that I can find here on the screen so I can unmute you. 23, okay. And sir, does it say the call-in user number, 10, 13, 14, 17, 18? All right. There are several different calling users. I'm trying to figure out which calling user. Let's see here. So we have. Just give me 1 second, Mr. Chairman.
Very well.
There we go.
Derek, someone else in the chat said they were here for this appeal also. I don't know if you saw that.
Yes, that is Councilman Schlafer. So he is here. I have a letter in support. I'm going to unmute the applicant. Mr. Ankri?
Hi, can you hear me?
Yes, sir.
Awesome.
Mr. Henley, this is a request to construct a one-story rear addition. Is that correct?
Correct.
All right, sir. Is there anything you'd like to add to your application at this time?
No, thank you.
Very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Excellent. Thank you so much.
All right, thank
And
you.
Mr. Chairman, we also have Councilman Schlafer on the line. He might want to say a few quick words about this appeal and support. I am unmuting him right now. Let's see here. Councilman Schlafer? Councilman?
Offer my support for this application. And as we've already discussed, I'm fully supportive of it, as is the community association and the neighbors. So thank you for your support on this.
Thank you, sir. Derek, I'm going to recall the matter of 2020-74, 1001 North Broadway, Wally Smith. Used first floor as clothing. Sir.
And I'm looking for Miss Smith, for Mr. Smith on the line here. And I do not see him. Going through the list. Let me check the chat feature one more time to see if he's back. And I do not see him here, Mr. Chairman. We can certainly table the case and call it at the end of today's hearing again one last time. But he was present. He had sent a message that he was here in the chat feature some time ago, and it is on the consent agendas. But we could certainly call this case again at the end of today's docket.
Very well. Attention to the regular docket at this time. We'll call the case of 2020-15, 2401 Aruna Avenue. Jawad Sheikh. Used portion of ground floor as 15-child daycare center and used portion of ground floor as office. Ground floor rear as office. Ag and title service and continued first and second floors as 2 dwelling units.
And Mr. Chairman, this case has been before the board several times. It's been postponed both because of the COVID-19 state of emergency, and it was also postponed prior for a posting issue. There were numerous community members who had appeared in opposition, and we do have letters in opposition as well for the requested uses of the property. I will turn it over to the planning department if there is a planning report for this particular appeal.
Planning department has no objection to the office use and has no comment on the residential use or the daycare use. Thank you.
Thank you, Mr. French. Okay, are you present?
I found Mr. Sheikh. I am elevating him to a panelist so he can provide testimony regarding his appeal. I am now unmuting him, and he should be live.
Good afternoon, board. Is everybody able to hear me?
Yes, sir.
Yes, sir.
Yes. Okay, great. Well, thank you so much for taking the time and hearing my appeal. I apologize in the past for the notice problem that we had. We got that rectified. I put in an application, an appeal for the back portion of the building to be used as office space and the front portion of the building to be used as a daycare center. We also had, my wife and I, we interacted with some of the community members, and after the last hearing that I was at, they had indicated that they would be in support of anything but commercial. This space, based off the information that I have on file, has been used as commercial space going back all the way to the police survey of 1931. It's maintained its retail commercial use, continued through at least 2002 without interruption. Over the years, it's used as a commercial grocery store, coin laundry, and a candy store at one point. I purchased this building about a year ago. The prior owner, was getting it equipped. He had a few applicants that were interested in renting it, and I believe, he had an application for a grocery store and other retail purposes such as that. I understand that it's a residential area, and it's a safe neighborhood, and we want to maintain the atmosphere in that neighborhood. So my wife and I are not considering any applications that's going to bring in too much foot traffic or any kind of negative attention to that area. So that's why we had decided, we would keep the back portion as office space. And, we had an individual that was interested in running a daycare center out of the bigger space, which we thought, would be very, low volume, consistent, patrons coming every day. It's not different people every day. We would obviously, given that it is a residential area, we would, make sure that we are regulating the hours of operation, so that way there's no disruption early in the morning, there's no disruption in the evening times. Our back office space, we have an individual who owns a dealership a few miles away. She wants to use that space, strictly for, just paperwork. There won't be any customers coming. There won't be any cars coming to that spot for registration purposes. It's just going to be an office for her to do her paperwork. As far as the front space is concerned, there are two large windows inside of the building. There is an exit way from there. So we've basically had it set up, for the purpose that we're trying to use it for. We also had, interacted with one of the members of one of the homeowner associations very recently. I believe the last time we were there to update our notice, which was a few weeks ago. So we spoke with her, and we asked her if there's an objection to that space being used as a daycare, what else they would want to see in that space. That was basically where the conversation was at that point. We're open to any adjusting anything that we need to adjust. The memo that we received from the planning office said if there is going to be a daycare center there, that we have to reach out to the parking authority to request a passenger loading zone. We have reached out to we've tried to reach out to the city a few times, but because of the COVID situation, it's been a little challenging. And the most recent information we had on file was, if that operation is going to move forward, then, we'll have to submit an application request to get a loading zone set up on Wheeler Avenue, which, we're more than happy to do. Aside from that, I understand there's, different inspections that need to take place. We're happy to get anything done that we need to get done to kind of move forward with this project.
Thank you for that. I have no questions. Are there any questions from the board at this time for this applicant?
Any other daycares in that area, sir?
One of the neighborhood individuals that lives in the neighborhood did inform us that there is a daycare center. He told us that it was 2 or 3 blocks from where our property is located.
Do you know how many children are, what the capacity for that daycare center is, sir?
I don't have that information, but I can certainly get that over to the board if that's required.
Is there anything else you'd like to add in support of your application?
At this time.
Okay. Mr. Chairman, there is, going through the list now, I see 2 hands that have been raised. The second hand, I believe, is an applicant for an appeal farther down the line, but I'm going to unmute the one, Ms. Hollis, and find out if she is going to testify in opposition to this appeal. So let me do that right now.
It'll settle. There's a lot of
Hollis, are you there?
Yes, I am in opposition of 807
Yeah.
East 43rd.
Reverb.
So that's another case. I think you have another device open right now. Can you put your virtual, can you lower your virtual hand so I know when to call on you again? Yes, that's perfect. Thank you so much. Mr. Chairman, I don't see any other hands raised, and I'm looking at the chat board. I don't see any other chat or any other messages for folks in opposition or in support of this appeal. To reiterate, we do have a number of letters in the record from community members in opposition stating that they don't want commercial activities to occur in this building. I think they've had problems in the past with other commercial operators, and they want this property to remain residential. But that is the content of those letters in opposition.
Very well, thank you. Well, Mr. Shake, I guess I'll leave you with the final word in light of at least the knowledge of that opposition by way of letter at this point. Is there anything else finally that you'd like to add in support of your application?
Yes, Chairman. So after the last hearing that I attended, you know, I had communicated with the seller of the building who I purchased it from, and you know, I had asked him if there was a homeowner association in that area, and he had alerted me, you know, given me false information and said that there was not. Had I been aware of that, I would have approached the members of the community prior to even, you know, putting this application through to kind of reach, you know, some kind of amicable, you know, solution to what they would want to see in that building. Having that said, after the last hearing, where some of the members of the neighborhood were present, I did approach them. I, you know, tried to have a conversation with them, you know, about what their, you know, concerns were, what we could do to kind of ease their concerns. And the response I got, you know, similarly to what the letters say, that, you know, they don't want anything commercial there, which, you know, in my opinion, this space has always been used for commercial purposes. You know, convert that commercial to residential now, it's going to require a lot of, you know, modification to, you know, the floor plans of that area, putting in full bathrooms, kitchens, whatnot, which, you know, that's not something that I was prepared to do when I purchased the building. So, you know, like I said, I understand if they've had issues with the prior patrons.
Mr. Shake, or did I just lose? Okay.
I'm sorry?
That's okay. I lost a bit of the last of what you said, but apparently everyone else can hear you.
Okay, sorry about that.
It's okay.
Yes, sure. Like I said, I you know, I don't want to rent to anybody that's going to be a problem for myself, or, you know, because I have 2 apartments in that building. I don't want my, you know, issues for my tenants either. So we're not going to be moving forward with any you know, project that's going to, you know, create a disruption for my tenants and also that neighborhood.
Very well. Any final questions from the board?
No.
Okay. All right, Mr. Shake, thank you for your presentation, sir.
Yeah, thank you for everybody's time. I appreciate it.
Going to now call the case of 2020-20, 428 South Bond Street. James Wolosen to continue to use premise as 2 dwelling units.
We do have him on the line, sir. Give me a moment to find the applicant.
We go ahead and ask for staff reports while we're searching for the applicant. At this point, do we have any staff reports for 428 South Bond Street?
Planning Department reviewed this application, looked at some records that were available to the department, which indicated it was an owner-occupied single-family dwelling, at least from 1928 through 1970. There was no record of a conversion permit being issued. There was an electrical permit issued to install 2 new electric meters in April of 2019, which was extended until October of 2019. But this did not establish that there was a lawful conversion of the premises to multifamily from single family. That this property is located in the R8 zoning district, and if a conversion would be approved, it would require an ordinance in order to do so. The department recommends disapproval of the application because the zoning code does not authorize conversion of a single family dwelling to a multifamily dwelling in this district. unless the applicant can provide the board evidence or information showing that multifamily use of the property was lawfully established. The board determined the application is approvable. Department recommends that it be subject to the condition that all exterior changes, including additions, demolitions, and alterations, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. This property is located in the Fells Point Historic District. Thank you.
Thank you.
And Mr. Chairman, from our review of city records, they match what Mr. French has testified to. The last authorized use that we have for this property is as a single-family dwelling.
I could hear very little what Martin said. Was that a yes, or are they in favor or not in favor?
Recommending disapproval.
Thank you.
Mr. Belozen, are you? Oh, I see that you're present. What can you tell us about this project, specifically with regard to the lawful conversion of the single-family status to multi-family?
Chairman Fields, can you hear me? This is Pete Previs.
I can, Mr. Previs, and I can see you as well.
Okay, we logged in as Mr. Wolosin just so Mr. Baumgartner would be able to find us better, but this is me, and the real James Wolosin, I believe, is logged in. I don't know whether he's brought up as well.
Problem. Go ahead, sir. If you.
Okay. Basically, Mr. Chairman, we are planning to present evidence. This has been a two-apartment building since at least 1982, when the predecessor Untitled owned it, and probably since 1954, when two separate Hunt families owned the property. I have with me here today Mr. John Svakianudis, whose parents purchased the building in 1982, and he's prepared to give testimony as to his firsthand knowledge of there being two apartments, two BG&E builds, and what have you. Secondly, I want to talk a little bit with regard to the conversion law. The original conversion law that went into the 1971 code, in either an R8, which the property is currently, or in a B3, in which the property was until Transform Baltimore, it was not considered a conversion to go from a one dwelling to two dwelling. That didn't occur until an amendment in the prior code that occurred in 1999. This property was purchased by the Svakianudises in 1982 and was established as two apartments when they bought it, but it had already been designed as two apartments. In 2002, there was a subsequent amendment that required BMZA approval. I don't think that's actually pertinent to anything that we're at issue with here today. But it wasn't until the Transform Baltimore that they took away the conditional use being a BMZA hearing and made it a city council ordinance. So therefore, I'm going to ask Mr. Svakianudis, who's present with me here today, with regard to his basic history that goes back even before his parents bought the building. Mr. Svakianudis.
Thank you.
You need to be sworn, Mr. Baumgartner. Hello.
Yes, sir. Mr. Svakianudis, can you please raise your right hand? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you.
Can you spell your name for the record?
First name is John. Second name is last name is Svakianudis. S like in Sam, F like in Frank, A, K-I-A-N-O-U, D as in David, I-S.
Yeah, and Mr. Svakianudis, your family had a business called JAK Construction going back into the 60s. Is that correct?
That's correct.
And how old are you now, sir?
64.
And when did you start working in the family business at 508 South Bond Street?
Actually, when I was 16.
Okay, so that would have been in 1973 when your parents bought the building where the construction office was?
That's correct.
And the subject premise is 428 South Bond Street. That is across the street from, half a block up from your contractor's
Yes,
office?
yes, you cross Eastern Avenue and you go to 428 South Bond Street, yes.
Okay, so your office is at the southwest corner of Eastern and Bond. The tattoo parlor is on the northwest corner, and this building is 2 doors up from the tattoo parlor, if anybody has a frame of reference. Is that right?
That's correct.
Okay, so your parents bought this property on October 12th, 1982, is that right?
That's right. That's
All right, and at the time that you bought it, were you were working in the family business?
Yes,
And it was already 2 apartments?
yes,
Okay, and do you recall them buying it from the Hunt family?
yes,
Okay, and that was Carl Hunt and Audrey Hunt, his wife?
that's correct.
And then there are other relatives, Zebeline Hunt and Zeri Hunt,
Yes,
and they had passed away, and Mr. Hunt, as personal representative, sold their half, and then the Carl and Audrey sold their half to your parents.
that's correct.
Mr. Previs,
Yes, ma'am?
may I interrupt?
Yes,
I 100% believe your client with reference to the fact that it was 2 dwelling units back to when he first started working at the property. I'm more interested now to see what proof you have that it's still 2 dwelling units. Are there 2 meters? Are there 2 electric bills? And so to the extent that you can, I don't know that we need, now that he's testified to that, I don't know that we need any more history on that.
Thank you. Mr. Svakianudis, you sold this property on January 7, 2019?
That's correct.
And up until that time, you rented both the first floor and the second floor out, is that right?
2 apartments, that's correct.
And going back history, it was always 2 separate PG&E meters?
As long as we owned it, yes, it was always 2 separate meters.
Okay, and then your parents passed away, and your mom's estate conveyed the property to you and your brother Gus?
That's correct.
But you continue to run the business and you rented this out?
That's correct.
All right, and then you sold it to the current owner, Miss Haymay,
Yes,
Miss Jang. And at the time that you sold it, it was still 2 apartments?
that's correct, yes.
Okay, and the tenants continued to live there until even after you sold it?
I know the tenants were living there as long as we owned the property. Now, what happened afterwards, I don't know.
Okay, and then, but then the current owners have applied for permits to upgrade, is that right?
Yes.
And you're 2 doors away, so you see what's going on,
Oh,
right?
absolutely, absolutely.
Okay.
Can you show me the bills now? Are there 2 people in the property now?
The property is currently vacant because they began renovations.
Okay.
There were 2 existing tenants.
How long has it been vacant?
Mr. James Willoson, are you present with us?
Mr. Previs, we have 1 user with just the first name James on the list. I don't know if that is Mr. Willoson or not. I can certainly unmute them. I think it might be, since he just raised his virtual hand.
Very good.
I will unmute him, and this is the applicant, and he can testify to board member Strachan's question.
Thank you.
Good afternoon, board members. In reference to your question about the tenants, so essentially once the property was acquired, we went through the process of getting the permits, and then the existing tenant that was there, they eventually moved out. The time frame, I believe, was in March of 2019.
And you began applying for permits in January of 19 when you first purchased it, Mr. Willoson?
Yes, sir.
Thank you.
You hear me?
This is Michelle Middleton. I guess just getting directly to Mrs. Strachan's point. Do you have any pictures of 2 meters? Do you have any bills to show that there are 2 bills, 2 different apartments?
I do have pictures of 2 gas meters and 2 electric meters.
Great.
If those can be submitted to the board via email, that would be helpful.
Perfect.
In addition, Mr. Chairman, members of the board, Mr. Svakianudis looked through his folder he has 1 folder each for both apartments. And in the one folder, we did find a BG&E letter with account number that indicates 428 South Bond Street, second floor. We couldn't find the anything else on the BG&E bills for the first floor, but we do have one that says second floor.
And has that been submitted at this point, sir?
Not yet. Mr. Svakianudis just handed this to me.
Okay, if you could download that or scan it and send it in to zoning office for the record, that would be helpful as well.
Thank you so much. So, with that said, I believe there may be two appropriate grandfather dates. One is when the old code was amended in 1999. Any use as two family dwellings prior to that would not have required a conversion, and being in a B3, they were permitted uses. In addition, in Transform Baltimore, the property was converted from a B3 to an R8, and therefore the property is clearly used as two apartments prior to June 5th, 2017. Unless the board has any other questions, I believe that we've made out a case that the property has been used as two apartments at least since 1982 and probably since 1954.
Are there any additional questions from the board?
Nope.
Okay.
Are we going to see these documents?
Yes, sir.
Mr. Cunningham, if they are forwarded to me shortly, I can forward those along to the members.
Okay, thanks.
I'm scanning the BG&E bill now to Mr. Baumgartner.
Great, terrific. All right, if there's no further testimony in this point, we'll conclude this case. Mr. Priebus, thank you for your presentation. Mr.
Thank you, sir.
And, we'll move on to the next.
Thank you, board members.
Thank you, Mr. Logan. Calling the case of 2020-47, 7 through 815 East 43rd Street, Carlos Levine, to use portion of premises as contractor storage yard. I'll ask for any staff reports associated with this matter.
So, Mr. Chairman, we have a number of letters in opposition. We also have I believe 8 letters in support of the appeal. We also have a letter in opposition from the councilman for this district, Bill Henry, a letter in opposition from the neighborhood association, which is at Wilson Park. I believe they are represented by Ms. Witt from the Community Law Center. I believe Ms. Hollis is on the line to testify in opposition, and I'll look for other folks as well. And I believe that Ms. Teal is going to be speaking for the applicant. I will try to find all these folks when it comes time for their appeal. So let me see if I can find the applicant first. And I would check with Mr. French with any planning staff report as well.
Great, thank you.
Right, while you search. Planning Department reviewed this application. This property is zoned R6. It is in the midst of a residential area, in fact, which surrounds this property. This property was last authorized for use as a place of worship. There is an indication that the applicant acquired this property in April of 2018 from trustees of a church. There is, however, no record available to planning staff indicating that a change of use has been applied for or authorized since 2018. The application itself was filed in response to a violation notice issued on February 12th of 2020. The department is therefore determined to recommend disapproval of the application because the contractor storage yard is a prohibited use in the R6 zoning district where this property is located. The zoning code does not authorize creation of new non-conforming uses, which a contractor storage yard would be in a residential zoning district. Thank you.
Thank you, Mr. French.
So, Mr. Chairman, I believe that Ms. Stacy Teal Locust is on the line for the applicant. She has logged in twice, so I'm going to unmute one of them and see why there's a double login. There might be some feedback. If there is, I will have to mute one of the two logins. So I will unmute the first, and we'll see if there's any feedback.
Very well.
Okay. Am I on?
Yes, we can hear you, Ms. Deolocus.
Okay. I don't see my video. Maybe I need to turn it down some.
I don't see you either, but I can hear you well.
Okay, perfect. First of all, I just want to say thank you, Chairman Fields and Mr. French. Thank you and the board for us to have this opportunity to talk about it. I think one of the challenges that we have with the application is that we are not asking for the property to be used as a contractor's yard for any type of storage at all. What we're seeking, if you look in the application under the proposed use, is that we wanted to have commercial, administrative, or construction company, like a dispatch for our staff and employees that work there. In regards to the violation that we received from housing, in regards to the millings, that has been removed. The cans that were in the back, they're there just for bulk trash removal. And it's also used by the Church of the Redeemer of the Lord, which is what in the one of our letters of support for our use there. In speaking with Mr. French yesterday, he mentioned that that because of the storage that we were being automatically denied for it, but based on the Transform Baltimore prior to, the property has always been a commercial building. It was built in 1967. And its inception, it was a distributing facility for a cola company. Then it escalated to a church, which is recognized on SDAT right now as the type of a church. And then on public record, it also states commercial and industrial. We do not want to use the exterior of the space to hinder any of the actual habits of the community. And in many cases, the exterior lot is being used by the community to support neighborhood association meetings, fellowships, giveaways, and cookouts that they have over the summer. They have parties, like little block parties there. And the church, along with Masters Construction, which occupies the property primarily, has always been a mainstay in the community. We are concerned, without pointing a finger anywhere, that all of this started basically in retribution, we feel, from an offer that we got from one of the city officials to do a swap for our property for another city property. Again, another commercial property being offered for commercial property that we were already occupying. We denied the swap that was offered by the city because we have a love and we are planted in the community in which the property is. We feel that we are compliant. We've responded to the city and got rid of the millings. There is no large dumping going on. It's just a huge lot around the building, which really we rent out to the contractors across the street who are rebuilding a school. They're using our lot actually for free for parking. Want to maintain the existing and established presence that we've always had in the community. The contractors that work at Masters Construction, they come in around 6 a.m. in the morning to get their dispatch, to get tools, and to have a little meeting in the office, and they're gone all day, not to return again till the next day. There is not a lot of traffic in and out the building. There's no noise that would hinder the residential use. And in all honesty, what we plead and beg the board is that you allow a conditional use in the R6 designation that I understand could mean limited non-residential use, that maybe we could just have it for admin offices, for dispatch, and the parking. We do not want to have any building materials on the exterior of the property, no cans, can trucks or big 18-wheeler trucks. Is a very small firm that we've never had problems with the community in almost 20 years. Masters Construction has owned the building since March 23rd of 2018. They bought it from a family trust who had leased the property to the Church of the Redeemed of the Lord. And for the 10 years prior to that, CRL, Church of the Redeemed of the Lord, use that property to hold the materials to totally renovate and build a brand new edifice on Old York Road. So we've had the community support the church as well as use the facilities. Some of the letters that we presented today are prayers that you see that we have not inconvenienced the community in any way. We try not to feel that we're being retaliated against by us not accepting the city's offer for a swap. We really want to stay where we are and where we've been planted and where our family is. And with that said, I just plead with the board that you can give us at least a conditional use to use the property.
Well, let me just confirm, Mr. Baumgartner, what is the application requesting? I thought it was requesting to use portion of premises as a contractor storage yard.
Sure. So the application itself, hold up.
When we submitted the application, I'm in detail on what we're proposing, but however, on the sign, the way it was interpreted when I went to the administrative office to complete the form, she believed that what I was asking for was a contractor storage yard. And maybe there was no other designation to call it at that time, but we do not want to store construction material in the parking lot or the yard. When I submitted the application, you should also have an overview showing the full scope of the size of the lot. The lot is at minimum 21,420 square feet, where the building is at minimum 7,722 square feet. So the building in no way, I would believe, would be considered a residential property. It is cornered on all sides with really no one around. There's another corporate building across the street, which is a school. At a corner to that is another church. In the rear, at least 500 feet to the rear is an apartment complex. And to the right, going up 43rd Street, it's still a set of row homes that are set back at least 100 feet from the property. The property is fully fenced and enclosed on all sides. So there's, I mean, a real stockade, a chain link fence plus the stockade with the privacy. So it's 3 tiers of fencing to the exterior of the front of the lot. You can't even see through. So there's a brick lot, there's a brick fence, then it's the chain link fence, then it's the shorter stockade type of fencing. But it's totally enclosed and there's no noise, you know, that they make their come in the day. The interior of the building is just administrative offices only. And we plead the board that we can keep the building, use it for the church, for the community, and for the admin for Masters Construction Company.
Mr. Chairman, the appeal requests, it says, as always, the rear of the lot has been used to dispatch service technicians, as well as hold millings for the pavement and parking lot on the church at Old York Road, and also provides secure place to discard building materials. So we don't, the application says, so we don't contrast and violate zoning code 5704. We seek to appeal the current use to a permissible code that will allow us to use the property in a manner that benefits the community as well as the nature of the business in which we operate. In your packets, you should also have satellite photography that we use for all appeals showing the property. The property does have a prior use that is non-residential in nature. I would call the board's attention to the satellite photography. It shows 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, at least 13 or 14 vehicles on the property. It shows what I believe is a fair amount of discarded materials. That could certainly be what the applicant has described as contractors who are working on the neighboring property being allowed to park on this particular lot. This particular property does have that history of non-residential use. A contractor storage yard is certainly not permitted in a residential district. The property would qualify as a neighborhood commercial establishment. in which an office would be a conditional use under that. But the board would have to determine that the use described as, I guess, a dispatch for some particular business would fall under that broader use as an office. And then at that point, it would be considered a conditional use.
I don't understand. This is a church property and a construction office or construction headquarters? What is it?
It is a commercial building where the church had used about 12 years ago. I was just trying to establish an ownership train, because in speaking with Mr. Fields, one of the things he stressed is that unless we could prove that the property was used in some other use than residential, because in R6 it's hard to get a conditional use. And I was just establishing a line of the chain that it's always been a commercial, a church, and actually the church was using it for offices and daycare, and the storage was on the outside for the building materials. But we did receive a violation for the millings, and that has been removed. The millings and put up to the church, it was for the church's parking lot. And we took the millings, resurfaced the parking lot at the Church of the Redeemer of the Lord and that other church at the top of the hill. So we will not store that again.
So what's the present use?
Excuse me?
What is the present use?
It's being used as administrative offices for the master's construction.
And you mentioned a couple times an issue of retaliation. What's that all about?
Well, I didn't want to I'm not making a big deal about it, but we were offered from Baltimore City a swap. Right across the street, there's a school, and that school is being torn down and totally redone. The city wanted to purchase or swap our building and make it the rec center for the school. And in turn, they would give us another city commercial building to use. And the ones that they offered, one was off of Sefton in Northeast Baltimore. They offered us Lake Clifton. They gave us a whole list of buildings that we could swap out. And after prayer and consideration, we decided to stay where we were because we were so nested in the church, we are members of the church, at CRL, Church of the Redeemer of the Lord, and we did not want to relocate. And soon thereafter, we decided, even speaking with Councilman Henry and his assistant, I think she's there on the board, we expressed our interest in not moving. All of a sudden, we're getting violations from the Baltimore, the control board, and we're waiting on a hearing for that. Then we got the violations for the millings and through housing. So we want to be compliant. We just want to stay where we are, close to where we worship and the community that we serve. And the letters that we submitted to you guys for review are just a few that we received before the pandemic really hit. I'm in tears and thinking, if I could only relate to you, the impact that we've had on the mothers, the children in that community. Do not want to lose that connection, and we beg you guys to reconsider.
Once again, you brought up this retaliation thing twice. So who do you think is retaliating against you?
Again, I don't think anyone, I hope that they're not. I just thought it was interesting that right after the swap was denied, because we've been there for many years.
Well, you shouldn't.
Masters has bought the property in 2018, and we've always had the millings there throughout the whole time. We've always resurfaced those parking lots. We've always done that in the past, and we never had a complaint. Even with the millings, you can't even see it from the street. The property has always been enclosed with brick walls and the chain link fencing with the slides in it. We only use the exterior of the lot to store the millings for the parking lots, especially when it's snowing and stuff. But shortly thereafter, if you can check our history, we've never had any housing code violations or environmental control board notices or anything. So we thought that maybe the simplest way to do this is if we're doing something wrong, especially as it relates to what was cited in the violation was the zoning code. We were in 5. They had us in violation of zoning code 5704. That's the reason for us really applying for the conditional use today before you, so that we would not be in violation of any zoning code.
So Ms. Teal-Locust, this is Derek Baumgartner. I had a couple questions. Number one, how long has Masters Construction been on the site?
They've been on the site. They've owned the property since March 23rd, 2018. However, 8 years prior to that, they had already been there as an associate of the church. They are the contractors that totally built the big church on Old York Road. So they had been there for many years.
But they were operating there without a permit, correct?
Say it again?
They were operating that business there without a permit.
They weren't operating Masters Construction. They were operating as contractors for the church.
But if they were using
facilitators for the church
construction materials, if they were using the lot for their trucks, that would be good to use. So if a contractor were using this site to put their trucks, to put their materials, to do work on adjacent property, they would still be using this lot as a contractor storage yard. So just because the business didn't have a business address here, if that's how they were using the property, they would by default be using the property as a contractor storage yard, which, if the photographs in the file are any indication, seems to be exactly what they were doing.
Well, I can't argue what the photographs say, but Masters Construction has a corporate address on Craft Hill Road in Perry Hall. I mean, their LLC license is recorded there as well. That's where they operated out of. When they bought the building in 2018, the church was already renovated and done.
And you can
the church had been done. I mean, in all honesty, and I know how it may or could be seen, but they weren't using the building as a contractor yard prior to purchase of the property. The property was individually owned by someone else.
But you can see how community members would not be happy with multiple vehicles sitting on a lot and a fair amount of debris in and around the lot. I mean,
well, right now the city is renting the lot for free. Right now, the only construction cars that are on the lot are from the city reconstructing or rebuilding the school across the street. Masters Construction doesn't even park on our lot at all. They're never there. We have a lease with the city that we don't charge them anything to park on their lot, even for the school. And I can provide that lease to you within an email within the hour.
That would be helpful. Thank you.
Yes.
So I'm looking at a photo attached to the materials dated February 12th, 2020. It has two green, what appear to be roll-offs or, for use of debris. Is it your testimony that the city is utilizing that in connection with?
No, sir.
Of a school across the street?
Excuse me? The two cans that are in the back were for the debris of Masters Construction. Is that what you asked?
Well, you said the lot is being leased by the city.
Right. They have
in
the
connection
front.
with the construction of a school across the street. So
Yes.
that's basically the city's use.
The front.
I don't know what's the front and what's the back. I'm just looking at, it looks like.
Well,
back
the
of
street
building.
side on 43rd Street, yes. The 43rd Street would be the front.
So, Mr. Chairman, if this will help clarify, I believe the photographs that are included in the file were the photographs that were in the city's system from the violation notice. So those were the photographs taken by the inspectors. And those inspections are almost always driven by neighborhood complaints. So more than likely a neighbor called and said that they're storing things on this lot and they don't have a permit. So Ms. Teal-Locust, there are two photographs that the board has in their file that show very, very large green commercial dumpsters, and then a fair amount of other, I think these are the blue bins that you were talking about as well.
Yes.
And then I see the millings I guess that's the rear of the property.
Yes.
But it's the large green dumpsters that are, kind of the call sign for construction debris.
Yes, that is correct. Since we got the violation, again, the millings have been removed. Those cans that are in the back, they are for the master's construction. We do deal with a lot of trash sometimes. So those dumpsters are in the back of the lot with a 10-foot gate. So I'm not sure how they got the photos, but it must have been from an aerial picture. I don't know. I tried to access those online and I couldn't. But neither here nor there, we take full responsibility for that. Those are our cans. And they're done on a contract where they can, we comply to that and we take full responsibility for that.
Sure. But so I guess my question is, if the request is to use the lot more as an office, right? So for some kind of dispatch, a dispatch use and office use wouldn't be trucks that have construction debris, dumping construction debris in a large commercial dumpster, right? So a dispatch is, we call someone somewhere else, and that person then goes out to provide service. So is the dispatch being proposed here, or the office use being proposed here, is it merely office work? Is it business filings? Is it receiving phone calls, making phone calls? Or will there be trucks of any size or any variety coming onto the lot and depositing any construction debris at all in any kind of dumpster?
Okay, there will be trucks that come in every morning to get their dispatch and work. There definitely will be admin throughout because the second floor is all administrative offices. The reason I can talk to my supervisor and see about the cans in the back. We kind of have a policy that the workers would just bring their debris back to the office every day. That way we can dump it and not to leave anything on the sites that they work at. It's not any flammable, it's just contractor grade stuff. But if that's an issue, we can state that as well. That's not a deal breaker for us. They can discard every day at the dump, whatever makes the community more comfortable. Definitely not visible from the front, the side, the back. You could be 5 feet up. You can't, it's totally enclosed. But whatever works, we're fine.
I don't understand.
I'm not sure I do either.
Whatever works. I don't know what you're even talking about, quite frankly.
Well, what I meant by whatever works is whatever you agree or whatever you think that we should do. Again, I'm a novice. We're a small business. We've been here for many years. And the issue with the cans, we believe that it wasn't a challenge because they were covered. There's no debris around the property in which is owned. And if the cans are an issue that would hinder us from using the property for administrative uses, then we will not have them there anymore. We've already conceded that the city had requested that we not have any millings or building supplies on the lot. That has been removed and we don't do that anymore. Totally off the lot.
Do you have any current photos of the lot?
Well, we haven't. I can email you some later on today. I can take current photos.
It'd be helpful if you could do that sooner than later.
Say it again, sir?
It'd be helpful if you could do that sooner than later. I'd really like to know what it looks like right now.
What email address should I send it to?
Ma'am, you can send it to my email, which is DEREK.
Oh, okay.
Darren, I
Yes.
think, sorry, I don't mean to interrupt you giving an email address, but I think what might help us is because it seems like most of us are confused or on the same page with Bill, is if we could at least hear from the opposition at this point, and then we can, she would still have an opportunity to respond after that, but at least hear from the community to hear exactly what the opposition is. I mean, maybe that will help to give us a clear picture as to exactly what is going on.
Thank you.
Sure. We have Ms. Witt on the line from the Community Law Center, who I will unmute in a second. And then we have a number of folks that have raised their virtual hand, which again is very helpful. We had a question in the chat feature about the virtual raised hand. Just to go over this again, on the bottom of your screen, there is a bubble that says participants. If you click on that bubble, it'll list all the folks who are participating here today. If you find your name on that list and look to the right of your name, there will be a small kind of virtual hand. If you click on that, it raises your virtual hand. If you click on it a second time, it will lower your virtual hand. So that is that brief explanation. There are a number of hands raised. I'll go to Ms. Witt first. And Ms. Witt, once I unmute you, if you can just identify yourself for the record, number one. And number two, if you know of other folks who are going to be testifying, if you can just let me know their names so I can go through the list and identify them. If you don't know of anyone else specifically, we'll just go by the raised hands and the chat feature. So I am elevating Miss Witt, and
I see her.
Becky, you should be live right now.
Hi. Hello, Becky Witt on behalf of Wilson Park Northern Neighborhood Association in opposition to the request. I am not sure who's on the line in terms of community members wanting to speak. I know that Councilman Henry had intended to be here. I don't know if he's here. And I guess I'll just speak very briefly to the legal aspects because I can't speak directly to the community experience of living next to the lot and seeing it all the time. I guess what I just wanted to say was the application before you is for a use as a contractor storage yard. I think we've kind of already gone through the fact that that's not really possible here in this residential district. It's not allowed. It's only actually allowed in certain industrial districts, not even in commercial districts. So anyway, so what is actually before you is not, you can't really vote yes on it unless there's some kind of time when it was allowed, but I don't think that has been presented, that information has been presented. So then there's this other kind of application, hypothetical future application being discussed with an office use, which is a possible option under neighborhood commercial, but that application is not before you. So I guess I just wanted to point that out and say that, you know, that could be a future application that we could discuss and try to figure out whether this dispatch model fits within the code's understanding of office use, but that's not what this case was advertised as. That's not really how it was described in the application. And so I would encourage you to handle that as a future matter if that application were to come before you. So let me think if there's anything else I wanted to say really briefly before I handed it off to community folks. Really what people, I think, from my understanding, were concerned about were public health issues relating to the piles of debris, especially with the school being completely rebuilt right now and reopening at some point soon, just causing particulate matter and that kind of thing across the street. And my understanding is that, well, I guess I'll leave it to the community members to talk more about when those piles came to be, because my understanding is that there was a big cluster of complaints at the end of last year in November and December, which prompted the investigation from HCD in, I believe, January of 2020, and which is the reason that we have this case before us now. Yeah, I think that's everything that I wanted to say. I think what you have before you is not really something that you can vote to approve at this point, just because of the nature of the zoning code. So I think that's it.
And were there any questions for Ms. Witt?
No.
Mr. Chairman, with your permission, I'm going to move on to anyone else I see who would like to testify with regard to this application. I have a chat request from a Ms. Singleton. I see you here with your raised hand. I'm going to unmute you. After I click on this, just give it a second or two to fully load, and then you can provide your testimony.
Sorry, Derek, I think Katrina Odom also is somebody who, if you can see her, she's a community member who wanted to testify. So I'm closing myself off now. Okay.
Thank you. Ms. Singleton, are you there?
Hi, hello. My name is Mrs. Singleton, Carla Singleton, and I am one of the ones that lives in the community. I live in the 4900 block of St. George's. I've been in the community over 30 plus years. That property was also a commercial property for C&P. I'm giving you a little history. And then also, prior to that, it was a church. And then Church of the Redeemed also used that lot for parking. Yes, you might have seen the meal, but you would have to go into St. George's apartment in the back to see that milling. That company there, they have helped the community. Wilson Park Northern Neighbors also have on Sundays in the summer, they use that parking lot to give away produce. They do a lot of things. When they did the back to school, Walter P. Carter, the Walter P. Carter over in that area used that lot for back to school celebrations. I know Wilson Park, historical Wilson Park, and then it's Wilson Park Northern Neighbors. So the residents around there, that has always been something commercial, and then it was church. And I know for a fact that when Walter P. Carter had an issue with them burning down their playground, that if Masters did not have cameras outside on their parking lot adhered to that building, they would not have found those gentlemen or young people burn down the playground. It helped out. I see them always helping because I drive through there every day through there, and I don't see anything. I see them in the morning on my way to work and on my way back. I see the people, putting things in the dumpster from their people who work there. But if any place that has a dumpster or some commercial place, they would have to dispose of it and have somebody pick it up, like Waste Management, pick it up and take it away. So I don't hear anything when I'm driving past there other than the gentlemen getting in their cars and trucks and going away. It's most noisiest right now is Walter P. Carter being constructed with all that Whitten Turner construction. So I really don't see or hear. I know that the neighbors of Northern Neighbors, the young lady, Miss Nia, she's not that far from there and live up that area. I understand that. But for me and some of my other neighbors in the neighborhood, we don't hear noise. And I know I'm not living down near 43rd Street, but I see what they do in the community-based part for me and people in the area. They help out the kids. They employ people or people that need help. It's never dirty. I also go to the Church of the
Miss Singleton, I don't want to interrupt, but I do need to interrupt. I'm just confused. Are you against this project or are you for it? Because it sounds like you're for it. I thought we were going to hear from opposition.
No, I am for the project. I'm sorry. I butted in because I am for the project because of the fact that they do help in the community. They are a pillar to the community. I am very overwhelmed at some of the neighbors in the community saying no. And if they lived in the community as long as I have, they know it was a C&P station there. for years, empty, abandoned. I know for a fact because I was there. I lived in this community all my life. So I'm just a little confused that when we have somebody there trying to clean it up and help out in the community, where we are going to say, oh, no, don't have it. These people are cleaning up. The gutters are clean, the street is clean, and they help out when the city trucks don't come through the community and clean up the snow. They actually, those people put those plows on their cars and go through to make a path for us until the city comes and salts and clean up the area. So I'm just saying, I'm a little confused here with the community saying, no, don't have this. And it's not a yard. I've never seen them store anything. I do see the milling, but I figured, hey, they fit in potholes. They need a lot of potholes fixed in the area. So I'm just a little bit confused with this whole situation. But I'm here to talk about, yes, I approve, and some of the neighbors in my neighborhood on the other side of Cold Spring also are approving this. I came in for the invitation. I told the gentleman I was calling to support him because I believe y'all guys need to know what's going on in there. I'm just listening in, and I'm at work also listening in on this conversation. And I appeal that the community should redirect, and let's change some of those forms that they filled out and make some clarity for you guys. I understand what you're not understanding, how that property is. But you have to go into St. George's Apartments on the other side to see what's inside the yard. Because
Excuse me, Ms.
everything else
Singleton.
is closed up.
Ms. Singleton, I think we've got your point.
Okay, thank you.
Thank you.
All right. The next up we have is Ms. Odom. Ms. Odom, I am unmuting you right presently. Ms. Odom, are you there?
I am here. Looking for. Oh, there we go.
So you are live, ma'am.
I'm here.
And can you give us your full name, please?
My name is Katrina Lynn Odom. I am the secretary for the Wilson Park Northern Neighbors Association. I have lived in the neighborhood since 1967, when I was born. And I'll keep it brief. I did send an email to you, Mr. Baumgartner. I believe you have that. So I'm not going to read all of that to keep it brief. I will say that the Walter P. Carter Lois T. Mary campus is going under the 21st Building School construction by the state of Maryland now, which is directly across from the 807 815 East 43rd Street property. The building in question had the Church of the Redeemed of the Lord name on it until June of 2019. So for me as a resident, I did not know that there was a construction company that was operating out of that site until I do know that some members of the organization were meeting with, I believe, members of Church of the Redeemed of the Lord and the construction company. I do remember when C&P was on that site. And I do know that farmers markets were being held at the site back in 2014. The Church of the Redeemed of the Lord has used that site for different community outreach events and the property. So that is not under contention. The contention that we have, because the new property, the new Lois T. Murray Walter P. Carter campus will be much larger than the former Walter P. Carter school. There will be 3 schools. Student bodies from 3 schools will be at that campus. Students from Walter P. Carter, Lois T. Murray, and Guilford Elementary Middle School. Students from Lois T. Murray and from Walter P. Carter get to school on school buses. The streets around the perimeter of the school are very narrow. That would be St. George's and East 43rd Street. In the letter, I have a screenshot of a photo of Walter B. Carter as it appeared back in 2018. There is a slope on 43rd Street, as denoted by the 21st Century Schools building website. It is a very steep rise. The grade change is over 30 feet. If you have two school buses, if you have a school bus and a fire apparatus, the fire apparatus do use 43rd Street. It is very tight because of the narrowness of East 43rd Street. The 21st Century School Board staff already notified us that there is not enough parking on the grounds for this faculty staff of the campus. We already know that, so we know parking will be an issue. I'm sorry, I'm not, as Miss Teal Locust mentioned, the state workers and the workers from Writing Turner do use the lots. Any available parking around the school is being used now for the construction project. As residents in the area, we can only imagine what it's going to be like when the school is actually up and running, how tight the parking is going to be. So we only imagine that that's going to be another problem. She did say a couple of things that we're wondering about. She said that, at the end of the day, the trucks the workers bring their debris to the office at the end of the day. The school bells for Walter P. Carter and for Lois T. Mary will be different. I think in an attempt to keep the school buses from clogging the arteries, they're still trying to determine how they're going to work with that. So with the addition of trucks, because she said there would be still trucks that come into the area, we see traffic jams. We're concerned, what about the required fire drills? What about the fires and medical emergencies that do occur? At the far end of East 43rd Street, at the Alameda, there are speed humps, which of course traffic has to slow down for. There are one-way streets, St. George's, and there's another parallel street. They're trying to determine, do we need to change the traffic flow? There has been talk about making the parking across from the apartment complexes on St. George's, putting in reverse angle parking, which would further narrow the parking across from the apartment buildings. So yes, we are concerned, and because by the admission that at this point there would be some debris brought in, and the evening hours there would be trucks coming in. We have a problem with the congestion. We already have congestion in the area just from the building project. There will be additional congestion. We're concerned about the safety of the children, the faculty, the staff in light of that. And yes, the protests have been coming in, and we feel that our protests are valid. In addition to the fact that the property is currently in an area that does not allow for a contractor storage yard as an R6 zone.
Yeah, I think that's not in dispute. Ms. Odoms, Mr. Fields, thank you for your presentation. It's true. What we had before us is only an application for contractor storage yard. It sounds like there are some offers to offset or adjust, what that request is, and it's frankly hard to track opposition to additional thoughts as to what might be changed in a proposal versus what's before us.
Mr. Fields, I have a question for Ms. Teal Locust also.
Sure, go ahead.
Okay, Ms. Teal Locust, so you said that the main offices for Masters Construction they're in Perry Hall, right?
Yes, you mean now?
Yeah.
No, they're operating out of 43rd Street.
So you don't do anything in Perry Hall anymore?
He has an office there.
Okay, do you have any other contractor storage areas in the city of Baltimore at all? Do you have any other property that you use as contractor storage, and do you have any other property that you use as dispatch?
No. Sometimes the building materials are dropped off at the properties that are being renovated by Home Depot. They just take it and drop it off at this the site of the jobs. We do a lot of fire restoration jobs throughout the city. What comes back is just packaging and things like that.
When you say it comes back to the property
Yeah,
issue.
we don't have any. We only have pickup trucks and little vans. Those are the workers, and then that's their privately owned vehicles of our contractors, the subcontractors.
So, and you also said you have a lease with the city for them to be able to use the property right now as they're redoing the elementary school?
Yes, ma'am.
Is the city using this property for contractor storage, or is the city just using it for parking?
No, they're just using it for parking.
Okay.
And they have drop off of some equipment, but it's the heavy equipment on that right side in the back they put back there.
So they sometimes use it as a place they sometimes use it in a similar fashion to you as a contractor.
But we don't have any big vehicles. They have the bigger vehicles. But yes, they're currently using it for the parking and everything. But we don't have big box trucks and those big bucket trucks. We don't use those things.
Okay. Those aren't
just vans and pickup trucks. Privately owned. We do not own the vehicle. So the only ones that are permanently parked out front, none of those vehicles belong to any staff member or executive at Masters Construction or Church of the Redeemed. All of the vehicles that you would see, I'd say, on the lot after maybe 11 a.m. would be that of the workers across the street. And prior to that, when the school was operating, we also let the school use the lot for parking.
Mr. Chairman, I think we're getting a little off track here.
We're kind of way off. Here's what I see. I understand that what's before the board is an application for use as a contractor storage yard. There's not, whether there was inability to call it something else, if the applicant is seeking to use the property as an office space for dispatch, but something other than a contractor storage yard, then I think for the benefit of the board and the folks who may wish to respond to it, oppose whatever it is the applicant's asking for, we all need to be on the same page as what's being sought. So the only thing that's before this board is a contractor storage unit. Is that accurate, Mr. Baumgartner?
That is, sir. So the appeal came up to our offices as an appeal for a contractor storage yard. It's not unusual that an applicant would provide a description of a use that doesn't contain the magic words of what the use is in the zoning code. Right. And then zoning administrator's office staff would do the best they can to put that narrative into a particular use. That's certainly how we evaluated it. And looking at the violation notice, which cited them for using the property for that use, looking at the photographs showing the dumpsters, everything matched what we thought that the applicant was requesting. If the use is something different, that would require an appeal. And then as you're kind of getting at, it would require reviewing it. Instead of a contractor storage yard, it would be some kind of neighborhood commercial establishment use.
Right. Okay. I'm just concerned about the continuing, certainly we want to have the folks here who are able to testify about the use, but all the commentary regarding how the property has been used in the past and what folks hope to do is frankly irrelevant to what it is that the applicant is seeking to do with the property right now. And it's difficult to think beyond contractor storage, given all the the accompaniments to the application, which include, as you said, the violation notices, the photographs, and all of those things. Because, I mean, we certainly don't need to have folks opposing something that's not being sought after, but the only thing we all know is the contractor storage yard use, which the code prohibits in this particular zoning district. I know that we had some other folks, I think, that were present or wanted to testify in opposition. I don't know if Councilman Henry is available or other folks. Let me take it to Ms. Theolokis. Are you still there?
Yes, sir, I am.
All right. You understand that I guess the concern that I have as a board voting on or deciding this application, which has been put in the category of a contractor storage yard. Frankly, it was probably the appropriate category to put it in, given everything else that was accompanying it. And that's what all of the opposition is opposing, use as a contractor storage yard. There are a couple of ways, or I guess a few ways that if frankly, what it would be is either a withdrawal of the application for a contractor storage yard, some modification of something that you're asking for. But it's always tough when you're modifying an application during a hearing. And we're all trying to get clarity on what actually is being sought, particularly with the school being constructed across the street, the city leasing the lot. So I'm really not even sure who's using the lot, really for what purpose, what equipment, trucks, the construction company has on the lot, intends to use. It's a lot. It's pretty amorphous at this point. I offer that to you just in terms of that's what I see. Again, we have opposition on traffic issues, because if it's not going to be used the way a contractor storage unit, maybe the traffic issues would be lessened. I don't know, but I don't think we're all talking apples and apples. We all may be thinking different things, and that's a little difficult.
Mr. Chair, if I could interject very briefly, we do have one person that has their virtual hand raised.
Yes, sir.
I recommend just unmuting them to see if they have anything additional to add, with emphasis on additional testimony. If testimony has already been given on any particular issue, the board does not have to hear it for a second time. But there is a Miss Evans that has her virtual hand raised, so I will unmute her to see if she has any additional testimony. And then I believe there might be one other person that we should check with. Again, with being a virtual platform, it's sometimes difficult to be able to see exactly who. In a live hearing, it's easy. Everyone lines up. But on these virtual hearings, it's much more difficult. So let me unmute Ms. Evans just to see if she has any additional testimony.
Thank you.
Ms. Evans, are you there?
Yes, sir. Good afternoon, gentlemen and ladies.
Good afternoon.
Do you have any additional testimony to offer in support or in opposition to this appeal?
I'm in opposition. My name is Sharon K. Evans. I live in the 4400 block of St. George's Avenue. My family, I've been in the neighborhood in Wilson Park for 67 years. My whole family used to live in the 4400 block. The Church of the Redeemed and the construction company, I'm hearing the testimony from Ms. Till and the work that is being done. For first and foremost, the city is not using the property at the construction site. It is the construction people who are building the school. That's who's using that. And the city has nothing to do with the people on that parking lot. My concern is they are not doing what Ms. Till is saying they're doing. They're still there every morning. They're moving stuff in and out that construction building. The Whiting and Turner do not have any of their property over there at that location. And the people are constantly moving. I'm right there at the place. I'm right on St. George's and I see everything. I'm hearing people talking, what they are doing. Church of Redeemed, Jerome Stokes is one of the guys grew up with us up here in the Wilson Park neighborhood. They had it for a while. It wasn't all this. They helped out the community. We have our own community. Wilson Park has their own community, and we're asking and we begging and we pleading. Take these people out of our community. It's not good. It's not a good structure for us. And that's just how I feel. Noise, debris, the dust. I mean, like I said, I'm here to share with you all. We've been one of them out. They moved in overnight, and we want to move out in the daylight. Thank you, board.
Thank you very much. Finally, we have a person that logged in under BMZA 0519. We're going to unmute them just to find out who they are and if they wish to testify on this case or any other case. So user BMZA 0519, are you here to testify in support or in opposition to this appeal with 2020-47, 807 East 43rd Street?
I'm in support of
Okay.
the master construction.
Okay.
Gwendolyn Jones.
Okay. Do you have anything to add to the testimony that we've already heard today?
Yes. What I wanted to add was that I feel that the master construction should stay in the neighborhood because I was one of the people that had a fire in my home, and they was able to rebuild my home by being close by. I have visited the office and the site in question, and they do store things like extra towels and materials that's needed for their jobs. And I was able to go and pick out what I needed from there without going, other places. So basically, a lot of things that they had there was on site so they can finish my house. And they also have been, like I've heard before, that they do help out in the neighborhood during the snow times. And I have also went down there several times for the farmers market that they had. I've only been in this neighborhood for about 14 years though. But during the course of the time that I've been in there, I only seen good things that they have done. And when I have went into their building, I'm not sure what the degree that they are talking about, because when I went in the back, all I seen was just the materials that they use on their different sites that they do construction at. And that's what I feel that they are using it for, not only to take care of their business or dispatch, but to also use it as the storage material so they could use on different projects. Or like they say, they did use it on helping to restore people who have had their house burned. And that was one of them.
All right, ma'am. Ms. Jones, thank you very much.
Okay, thank you.
All right. Mr. Baumgart, I don't know if you're able to determine whether or not we have anybody else in opposition to this application, so we can turn it back over to Ms. Steele and conclude this.
Sure. I do not see anyone else who has their virtual hand raised. I think we've heard a pretty comprehensive evaluation from both sides of the appeal, and I would turn it back over to you. I can unmute Ms. Teal Locust. If I can find you again, ma'am, there you are. And you can give your concluding remarks for the board, ma'am.
Board and Chairman Fields, again, thank you everybody for hearing our request. In all honesty and sincerity, we want to operate space for administrative offices and dispatch of the vehicles owned. We hear the complaints of the opposition, and this is our first time hearing this from the neighborhood that did complain. In regards to the dust and the smoke that they may be experiencing, I challenge that. Is that recent, based on the construction from the school? Is that all and fully accountable to Masters Construction? I will definitely talk to Carlos and Calvin and bring it to their attention that there are complaints of dust I like to believe that we keep the facility clean and safe. You have my word that later on today, you will have a copy of the lease that we have, also have up-to-date current pictures of the full exterior of the building. Our prayer is that once you consider the information presented, that you will allow a conditional use for us that will allow us to still have the R6, but just a condition for the office space and to dispatch our workers in the morning, and that's it. And one more thing, I'm sorry. In the application, when we went to apply, I understand that the first page of the application does say use a contractor storage yard, but in application process, the clerk there identified that that's the language that should be used. However, I tried to be as explicit as possible on this page of the application in stating exactly what our request was of the zoning board. Our request was never to use the property for contractor storage yard. We do not store contractor material outside. The millings that were there were really for the church, and we mean no harm to anybody in the community. And on the behalf of Masters Construction, I personally want to apologize to any neighbor or citizen that they feel harmed by us, and please let us know if we have in the future. But thank you for your time.
Thank you, ma'am.
Thank you, Ms. Theolokis. That'll conclude the presentations on matter number 2020-47. Ready to move on to the next matter?
Please.
Okay. Case number 2020-61, 2224 Madison Avenue, Adam Carballo, to increase from 5 to 7 dwelling units.
Yes, sir.
And Mr. Chairman, we do have a staff report with a number of letters from the community on this one. I believe Mr. Bob Henry from our office is on the line. Hey, Bob, you there? My apologies. Hold on one second.
1 second. I didn't hear the question.
My apologies, board. I am going through to find this.
Can you hear me now?
Yes, sir.
Okay. Ready?
Yes, sir.
Okay. We've received 37 letters in opposition and 2 letters in support. 34 of those letters are identical one-paragraph statements individually signed by the neighbors of the subject property in opposition to the proposal. The more substantial letters in opposition bring up the following points to support the board's decision to disapprove the proposal to prevent overcrowding of land and undue concentration of population. Basically, this is a 5-unit building that covers most of the lot, if not all of it. There are no parking facilities for the residents, let alone visitors. There are problems with their current residents' ability to realistically dispose of trash, as evidenced by a couple of overflowing trash cans and bags blocking the sidewalk, waiting for trash pickup. Realistically, there's no room for the needed and safe trash containers. The existing small units force residents and their parties to gather and move outside to the front of the building, creating noise and trash, prompting many calls to 311. Getting the existing residents out of the building in case of an emergency or fire is currently a problem with just 5 units. Additional arguments bring up the need to consider that this and the adjoining structures were originally built as owner-occupied single-family homes. But today, the growing number of absentee landlords and renters increasingly outnumber homeowners. Individual homeowners will be forced out, leaving the city with yet another poorly maintained slum. To conclude, the 2 additional units would make these problems worse, not only for the neighborhood, but for the building's existing and proposed new residents. The letter in support. It's their understanding that the property is in a C2 zoning district, which allows for the 7 proposed units. The only thing that's in question is the 2 additional parking spaces, requiring a variance. It is also their understanding that the property would qualify for the parking exception under Section 16-601 of the zoning code, since the building is greater than 50 years old. In fact, they don't understand why the zoning administrator disapproved the permit to begin with. In any case, they have no objection to granting the on-street parking variance and support the approval of the appeal. The building covers the entire lot and is so a practical hardship in complying with the current zoning regulations. The property is a 5-minute walk from the metro. There are 2 high-frequency bus lanes close by. The property is walkable and bikeable. This is a location that the city, along with the neighborhood organization, should be supportive to increase the housing supply. Regarding solid waste, this property has no rear alley. I would encourage a thoughtful solution for the residents to store their garbage and recycling for pickup, potentially reaching through a dialogue with the property owner, Upper Utah Madison Neighborhood Association. A possible solution might be installing some sort of attractive, durable waste receptacles along the side of the property. In such a scenario, a minor privilege permit from DOT would be needed to be obtained. In any event, the combined, consistent maintenance of this property, just like any other property, is very important.
Who is that letter from?
The letter in support was from the people across the street at 2224 Madison. And the letter of opposition is a compilation of 34 letters.
Thank you.
Okay, Martin.
Mr. French?
Planning Department reviewed this application, noted that this property is, as mentioned previously, in the Utah Place Madison Avenue Historic District. Any exterior alterations which might be required as a consequence of possible approval of this application would have to be reviewed by the Commission for Historical and Architectural Preservation and approved by them. The department notes that, yes, this property does cover its entire lot. Therefore, there is no parking available for current or potential additional residents. And note that there has been community concern about the parking question. The department has no objection to the application, but notes if approval is granted by the board, approval should be subject to the condition that all exterior changes, including additions, demolitions, and alterations, are completed or installed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, Mr. French. Mr. Carvalho?
Promoting Mr. Carvalho to a panelist. He should be available in the next couple seconds.
There we go. Can you hear me?
Yes, sir.
Mr. Carvalho, how are you?
Thank you. Thank you for letting me speak on behalf of the ownership. As previously mentioned, this property is 100% lot coverage. It was originally permitted for renovation back in 2014. The current property owner, Brad Blickenslaff, who I believe is still on the call as well, owner of Priscilla Properties, owns a number of buildings in the area, and is actually a property management company. They're local to the neighborhood, and sort of operate a number of buildings in the area. As far as I know, the building is actually not occupied. It had when Mr. Blickenslaff purchased the property, we completed the interior renovation to the above units. I've been in the property. Most of the units are 2-bedroom units. They have very nice finishes, very nice kitchens, granite countertops. There is actually just to sort of speak point by point to the opposition letter, there is actually a fire escape on the back of this property. There is a pedestrian alley that sort of connects to the back of this property. Unfortunately, it doesn't. There's no vehicular alley, but there is a pedestrian alley and a fire escape on the back. These are not bad units. They're actually very nice. And the renovation, there's really no addition we're proposing. The 5 units above have been renovated. There are 2 additional units in the basement that we're trying to get sort of legally put into place. From a lot coverage standpoint or a lot calculation, we are allowed to have these units, and it's just a parking issue because we're off street. There is no ability for off street parking for any of the units. We did reach out to the community group. We did have a virtual hearing with them. We sort of listened to their concerns. They did have a concern about trash, where all these trash cans go, and we offered as a solution to create some type of trash corral that would, basically along Clendenin Street. The Clendenin Street is actually quite a wide sidewalk there, and we even sent some images for other trash corrals that I've seen around the city as a possible alternative. I sort of left that virtual hearing feeling as if we basically were on the same page, and the impression that I got was that they were satisfied with some of our responses. It sounds like they're not as satisfied as I thought they were. As far as entry into this lower area, there's an existing areaway set of stairs. The basement was used for some type of use previously. So again, we're not proposing to have any changes on the outside of the building. We're not proposing any additions. We're simply just trying to renovate those existing spaces that already exist. Like I said, like I said, the property owner and management are a very well respected property owner and management company. They're by no means sort of an out of town sort of slum landlord type of operation. They are local. They have several buildings in the neighborhood, and I think they have an excellent reputation.
Okay.
However, that being said, the reason why we're here today is that we need a parking variance, not necessarily a variance on the number of units. And given the fact that the building is full lot coverage, there really is no opportunity for parking.
Mr. Baumgartner, do you confirm that all that is being sought at this point is a parking variance, or is there density?
I think he's on mute.
All right.
I had muted myself and I forgot to unmute myself. Mr. Carvalho is correct. The only variance requested is for parking. This property is in a C2 zoning district, which allows for quite a bit of density. I believe it only requires 225 square feet per dwelling unit. So 7 dwelling units would be allowed by right. The building does occupy the entire lot, and there's no rear alleyway for any kind of vehicular access anyway, even if it wasn't full lot coverage.
Okay.
Like in that area?
I'm sorry?
What's the street parking like in that area?
If I can pull up I'd be happy to share my screen of Google Street View, or if anyone kind of takes a look at Street View, on Clendenin Street, there's very few cars parked on the street at all. And there's parking spaces on the street view version right across the street, right out in front of the building as well. I mean, I've personally, every time I've gone to the building, and I've actually done worked on other properties in that neighborhood as well, and I have never had any issue parking during the day. I'm not a resident of that neighborhood, so I can't speak to all times of day and night, but I've never personally had an issue when I've gone to that area.
Is that a church at the corner?
Which corner?
Block, so the house or the building is at the corner of Clendon Street and Madison, but looking at the map, there seems to be a church at the opposite corner.
Yes, ma'am. It does look like there is a church. Yes, at the corner of North Avenue.
So I'm assuming that if parking is an issue, it could very well be mostly on Sundays when church is in service, although albeit not right now.
Possibly not, no. And it looks like there is also another church.
Just down the block in the direction. It's surrounded the church on either side, essentially.
Yes, ma'am. Yeah, I mean, it looks like the church at McCullough and Clendenin actually has their own surface parking lot, though.
Okay.
There's another church on Madison that's just past Clendenin. Like if your back is to North Avenue, there's a gray church on the right hand side. Is that what you guys are talking about?
It appears there's actually 4 churches all in this area. There's 2 on one on North Avenue, one at the corner of Madison and North Avenue, one at the corner of Clendenin and McCullough, and then another one further up Madison.
Yeah.
It's busy on Sunday.
A lot of churches, yes.
And Wednesday, I don't know.
Right. All right, thank you.
So, Mr. Carvalho, is there anyone you have in support of, is there anyone else to testify in support of the application, Mr. Carvalho?
I did not bring anybody with me unless Mr. Blickenstaff is on the line if he'd like to comment.
Mr. Carvalho, is he logged on the web platform or has he called in, if you know?
I sent him the link, so he may have, I can't see him, but he may be as an attendee.
Okay.
If you
And
can
that
see him.
we have a number of folks that have their virtual hand raised. I can't quite tell if this is for opposition or in support, but Mr. Chairman, we can go through the list of folks. For folks listening, again, once the board has heard testimony, they do not need to hear it again. So as we go through the list, if there's additional testimony that you would like to offer, you're certainly welcome to do so. But testimony is often not helpful. But if there's additional things that you would like the board members to hear that are relevant to this appeal, you can certainly testify. So the first person we have on our list is a BJ Douglas. I'm unmuting you. Mr. Douglas? Mr. Douglas, are you there? Yes, sir, you are unmuted. Mr. Douglas, BJ Douglas. So we're having a similar issue to a prior appeal where people are self-muting themselves. Mr. Douglas? So we will come back to him.
Okay.
Going down to the next person in line. Let's see who we have here. We have a Katherine, I guess that's Henley.
Hello, can you hear me?
Yes, ma'am.
Great, hi.
Can you provide your full name, please?
Sure, my name is Katherine Henley. I live at 2334 Madison Avenue. I'm just about 500 feet away from the property in question, I'm also on the Reservoir Hill Improvement Council board. I am testifying in support of this variance. Not only am I in favor of more housing and higher density throughout the city, I think that this property in particular has several factors that lend itself well to the 2 additional units. The first is that it's already an existing multifamily building and a very high quality existing multifamily building at that. The 2 additional units, I think, will be a marginal increase. And I found it kind of funny in the opposition letter to hear that they had claimed that the units were so small that people were going outside to spend time outside, which I don't think really speaks to the quality of the units or the size of the units, but more to the fact that our neighborhood is very social and people like to spend time outside and spend time with each other. So I would not take that as an indication that the units are too small. The second point is that that location has very high quality transit options. It's about 300 feet away from a bus stop, which is a high frequency yellow route. And there are bus lanes currently under construction on Main Avenue, which will create even higher quality transit connection there. And it's a little bit over half a mile from the nearest metro station, which is also a very, very high quality transit option. So I think increasing the number of units in this property to 7, regardless of the unavailability, the lack of off-street parking. There's, first of all, plenty of on-street parking and lots of high-quality transit options in the area. So I am in support of this variance.
Thank you, ma'am.
You're the RHIC Joint Housing Committee. What's RHIC?
That's the Reservoir Hill Improvement Council.
Improvement Council. Okay. And you made a point in your communication that letter of opposition was not from your organization. Your organization's in support.
Yep, that is correct.
Thank you.
All right. Moving on to the next in line on the list is a Kyle Gardner. Mr. Gardner, you have been unmuted.
Hey, can you hear me?
Yes, sir.
Great. So good afternoon, board. Thank you so much for having us have the opportunity to opine on this variance. Again, my name is Kyle Gardner, and I'm a resident at 2334 Madison Avenue. And I come to speak in favor of this application without any conditions related to it. So I'm going to speak sort of first on just the general condition of the area. I definitely endorse everything that the prior speaker said, insofar as it's certainly being an area that can support having 2 additional units. I am looking outside of my basement window right now, and I can see 2 parallel parking spots on my block that are readily available. And even in this lockdown, there's extremely excessive parking on Madison Avenue. I think that it's also important to highlight with the incredible accessibility to transit, both light rail and the subway system are probably a 10-minute walk away. The subway system probably less. There's also routine bus service that Baltimore City should not be concerned with competition for parking when we as a city should be trying to move towards maximizing our density and trying to ensure that individuals have the capacity to take advantage of the wonderful benefits of this city without even necessarily needing a car. But what I also did want to speak about specifically related to this application is that the nature of public hearings like this skew towards amplifying the voices of neighborhood residents who are well-intentioned but routinely oppose changes to their community. You could even hear in this application some of those pretextual justifications relating to the notion that a 2-unit enhancement would create slum-like conditions or that it would be a fire hazard, which are really not necessarily even in the content of what this board should be considering. Those should be building permit considerations, if anything. You also hear things related to annoyances related to construction or concerned about parking, like was referenced previously, or even the notion that multifamily housing creates undermaintained properties, or that the residents of multifamily units, who are typically renters, do not necessarily invest in their community in the same capacity as homeowners. And I really wish to dispel that notion not just in the nature of this specific application for literally 2 increased units here, but across the wide variety of applications that I've already heard sort of discussed in the 3 hours that I've been tuned into this meeting. It's incredibly important to recognize that there's this vast majority of residents surrounding and abutting these properties who simply lack the time or resources or passion to come to these meetings and say, I'm dispassionate about this, but I think that it would be on net good for the city. And that's what I'm here to say, is that I view these 2 units as a variance that allows 2 more families to be closer to their jobs. It's 2 more families who can walk down the street to the Dovecote Cafe, which is one of the most successful coffee shops in the city. It's 2 more families who can enjoy German or Madison Park. It's 2 families who can keep eyes on the street, check in on neighbors. It's 2 families who might use all the abundance of transit options that we have available to us. It's 2 families who have access to the wonderful architecture in this community as well. So, all that I really wish to emphasize to BMZA in supporting this application is to stress that the costs that every single person is imposed upon to have to go to these hearings and have to adjudicate all the myriad of marginal concerns related to runoff or to parking or to trash. While I am appreciative of the fact that abutting properties often face short-term costs associated with change, the reality is that by allowing these disproportionate voices to speak so loudly as to block daycares or very small construction firms from successfully operating, on net, it makes our city, I think, worse off. And so I strongly support this application for 2 additional units. I do not think that it will impact on-street parking at all. And even if it were to impact on-street parking, I think that is fine because there are an abundance of alternative mechanisms for moving around our city when you live on Madison Avenue. I strongly encourage there to be no conditions associated with approving this variance. And I strongly support in future meetings, if I don't have the capacity to speak my support for variances or upzonings, to state unequivocally that I am somebody who will always support increased density, increased residential density, and increased commercial development in Reservoir Hill. I think it makes our neighborhood more vibrant and more successful, and I really appreciate your time. Thank you.
Thank you so much.
Thank you.
I don't know that we need to hear from any other supporters if they're going to say the same thing. I'm just a little concerned because it's 3:30 and we have a significant docket left to go.
I'd like to suggest we put a time limit on the
Well,
testimony.
and also just a reminder that if it's repetitive information, we don't need to hear it. I mean, I think we can say for the record that they appeared and they're in support of it, but we don't need to hear. And that's not to detract from the supporters that have already spoken. They've all been very helpful. I'm just starting to get a little concerned that we're letting things go off the rails here as far as timing and repetitive testimony.
Is there anyone else waiting to speak on this matter?
When the next person we have, I believe, is opposition. Melda Washington.
They can't hear you.
Melda Washington, I'm taking you off mute. You are live.
Ms. Washington?
Can folks hear me still?
Yes.
Great.
Yes.
Ms. Washington, are you there?
Yeah. Hi, can you hear me?
Yes,
yes, ma'am.
Oh, hi, how are you? Yeah, I actually wanted to say a few things, well, quite a few things in opposition. I actually have a bunch of data with you that I can actually share with you regarding the parking situation. Currently on Madison between North Avenue and Whitelock, there are a total of like 87 parking spots. There are 52 pull-in parking spots, like 7 parallel, and there are 28 parking spots like on the other side. Now, there are 57 building units, single units. Within those units, there are like 1 two-family multifamily unit, 3 units with 3 multifamilies, and 1 unit with 5 multifamilies. So there are 73 units there that have to share these 87 parking spots. Now, out of all those units, 7 of those units have no parking at all. They are all 100% on-street parking. So that's just a little bit of data to share about the parking situation. And so let alone now with people being home because of the pandemic, and also to the gentleman that spoke previously, you would know that Dovecote unfortunately had to close because of the pandemic. They weren't able to stay open, so they had to close. So the parking situation is just overcrowded. And I'm on Utah Place, and believe it or not, Utah Place is just as bad, where we park on Madison because we need parking. But the 2 units are just, it's overkill for this community right now. It's too much. It's too much. Not only that, I don't think it's going to bring in the families that people envision it bringing in. And I'm not saying anything against renters. I live next door to 5 renters. And so I understand the parking situation, because when they pull in, they don't care that I live here by myself. And I'm looking for 1 parking spot. And it's that bad. The parking is that bad. So anyhow, that's speaking of the parking part. The other thing is, I wanted to, hoping you would hear from some of the people that wrote letters regarding them living really near that building, and what they're experiencing as far as the effects of this density now, which is not a good idea for this community at this time, and really at any time, really.
Ma'am, I understand that the only variance before the board is a parking variance. Is that correct, Mr. Baumgartner?
Yes, sir. That's correct.
Okay.
It's not an issue that we're here to consider.
Okay, well, the parking I've already addressed. You can tell how many units there are. I've done the walk, and I've done behind, and I know that some people are able to park in the alley. Some are not. Some actually have gardens. They've been here for years, and we've been here for a long time. Not me, but a lot of people have. So they've fixed up their housing. But then again, for just this additional parking, even though you say it is 2, it's not. If you have a family in there, you better believe they're going to have 2 cars. Next door, I had a roommate, and then he got a roommate, and then the roommate had a girlfriend who moved in. So there are 3 cars. So there's no way that you can control the amount of cars that are coming in. But already, this street is already parking dense. There's not enough parking.
Okay. Thank you, ma'am.
I say something?
We have your
One more. Yeah.
The gentleman that talking.
Sir, what is your name?
Sir, your name?
Oh, my name is Rolando Maxwell.
Oh, Rolando Maxwell.
Okay. There's a couple of things the gentleman that represent the owner, the management company. My concern is he stated that the basement was already in use. Okay. He talked about a fire escape existing. My concern would be, how, if you all approve this 2 unit in the basement, they will have accessibility to get out in case of a fire.
Right.
And then the next thing is that, and I don't see no alleyway. They actually in existence sort of a garage, a 1-car garage there that appears to block the entire back of the where the fire escapes are.
Yeah.
So I don't know where this alleyway that he's talking about, that in case of a fire, they will have access to escape.
Yeah, I understand what
All
you're
right.
saying.
Hold on a second, sir. Let me interrupt you for a moment.
Sure.
With regard to these safety issues and fire escape or no fire escape, I think while those are things we can generally take into consideration, again, the board is being asked to make a decision on parking, right? I recognize that was part of the applicant's presentation, but again, we're focused on the parking variance. That is the sole issue that the board is here to decide.
So the board is not here to decide about the 2 additional units.
Is there access to a fire escape or any kind of access to emergency exit?
So, Mr. Chairman, I can address that. So all dwelling units would have to meet building code requirements. So fire access, that's a building code requirement, under the city fire code. So things of that nature are not within this board's discretion. So in this particular case, it's those 2 additional dwelling units trigger the requirement for 2 additional parking spaces. So that's why the only issue before the board today is related to those 2 additional parking spaces.
Thank you, Mr. Baumgartner.
Yes, sir.
Sir, is there anything else you'd like to add on parking that we have not heard?
No, other than
Not
the
really,
fact that,
just that there's
yeah.
really no way to park. I
Right,
understand
right.
some other individuals talk
Right.
about,
Right. We've walked around, we've looked at the parking.
Okay, parking is your issue. I understand. Thank you so much. Is there anyone else that we, who we're waiting on, who wishes to be heard on any parking related issue that has not already been discussed?
I think there's one other person, Mr. Chairman. Let me just go through the list here. Ms. Hawks? Ms. Hawks, you've been unmuted.
Yes, you guys can hear me?
Yes, ma'am.
Okay. I would just like to state, so my name is Michelle Hawks Cuellar. I am a resident at 2337 Madison Avenue, so right up the street from the property that's asking for the zoning variance. And I am in support of allowing the 2 units without being able to provide off-street parking. One of the things that has not been mentioned by anyone is that this block of Madison Avenue is full of vacant houses and vacant properties. And I would much rather see a property that is currently vacant being inhabited by neighbors than having to call 311 because we keep having people breaking into vacant homes on the street. So in terms of density and overcrowded, that is not the case. Even right now that everyone is home, as other callers in support have said, there's plenty of parking on the street, especially as the closer you get to North Avenue as you're going away from Whitelock. And I would say about 3 of the churches that were discussed are not active. One of them actually doesn't even have a roof. So these are not churches that are holding services where there's going to be a lot of people coming to worship on weekends. So that is not an issue. There's no overcrowding. Parking is plenty at late at night during the day when there's street cleaning and we can't park on one side. That has never been an issue. And then there are a lot of homes, not all of them, mine does not, but there are a lot of homes that have parking behind their homes and people choose to park on the street. So if we start having less vacant homes and people, there is less parking, a lot of people have access to their own parking pads. And in terms of for the trash, which was something that was brought up as opposition, there are also many houses, mine included, that do not have vehicular access to the alleys, and trash pickup happens in the front. So if they would do an enclosure for the trash cans, I see no problem, and parking is just not an issue. Thank you.
Thank you very much, ma'am. I think can we get it back to Mr. Carballo at this point? Mr. Carballo, is there anything else you'd like to add at this point?
No, I think we've sort of discussed everything that we wanted to discuss, and I have nothing else further to add.
Very well. Terrific. Thank you for your presentation, sir.
Thank you.
Mr. Baumgartner, before we go to the next matter, can we have just a 2-minute break?
Yes, sir.
Thank you. I'm going to cut off the mic and video as well. Thanks.
It's 3:38. We'll reconvene at 3:40. Mr. Douglas, are you there? Mr. Douglas, are you there? Sir, you are muting yourself. Mr. Douglas? Mr. Douglas, are you there?
Hello, I'm here. I'm trying to get in and we can't get in.
All right, let me see here.
Can you hear me?
Yes.
Oh,
Can you
okay.
hear me? So the board is on a recess right now. They'll be back in about 1 minute.
All right, no worries. And then I will be able to speak, sir, ma'am, sir.
That's correct. You're going to be testifying in opposition?
Yes, I am.
Okay. Is that in opposition to the parking?
Yes, but this is a problem that I have right here. Is on the docket. It says on the docket the 2 units.
That's correct.
But this is, if you're not, I am in opposition of 2 additional units because the building is right now in violation. I would love to say this because this building has 5 apartments and it's supposed to have less than 4 apartments in order to be in not being violated by the 504 laws. Okay, and that means that it is not handicap accessible to anyone who wanted to rent that apartment, and that building totally is in violation. This is the reason that many people who looked at that building did not purchase the building, and that because we knew that you have to have a person living in that dwelling who owns the home in order to take the apartment thing under. And these people have not done that. And now they're speaking about adding 2 apartments. That's absolutely, to me, absurd because they're already in violation. The only reason that we did not, we're a really good neighborhood here. The people who came on in saying that they were for this, actually, sir, I don't know who these people are looking out their windows, looking at parking spaces at 1:30 in the day when most people, everybody is not on at home. There are several people who do have things that they go out and do during the day. And I think it's unfair to those of us who live in this neighborhood, who have been here for many, many years, to have to deal with 2 additional apartments and more parking spaces. So because the docket says, and because I know I don't want the city of Baltimore hello, I'm here.
Ma'am. Okay, so there's 2 things. Number 1, we're not on the record right now because the board members have recessed for a minute or 2.
Okay,
right now. But number 2, I just want to let you know that this board only has the authority to adjudicate zoning issues.
I know it, but the zoning, but it says on the docket 2 additional 2 units.
Ma'am.
And that's what it says. Wait, just a second. I'm gonna let you finish, sir. I'm gonna let you finish, sir. But I just need to say this one part. It's kind of.
Finish. I'm trying to be respectful. I'm not trying to cut you off. I'm trying to explain that is the posting for the property because that's what was requested. That request only triggers a parking variance. In this zoning district, they can have 7 units by right. That means the density that those 7 units are not at issue. So that's why
they cannot. Okay, sir. Okay. Yes. Well, who? I would like to speak to the board because you know what, sir? It is not that building. It is not allowed 7 units because it is not 504 in compliance.
And I'm telling you that is not part of the zoning code, ma'am, and that the board does not have the authority to regulate things outside of the zoning code.
Okay, all right, but I would like to know who has the authority to regulate that part of it.
The mayor and the city council of Baltimore.
The mayor and the city council of Baltimore?
That's correct.
Okay, and are you saying that this property at 2224 is zoned for 7 units?
That is correct.
All right, but what about the violation of accessibility?
That is not in the zoning code.
Okay, I want to speak when the board returns so I can be a part of the record.
You're certainly welcome to, but I would reiterate that it's getting late in the day and the
It's
board
okay.
won't
It's
hear
okay. I was
issues
trying to get
regarding
on
zoning.
earlier. The people who were in who were for this, you guys let them speak a very long time,
Well,
and
because
no
they were
one said
testifying
that they
about zoning
cannot.
issues.
Okay,
Well, because
no
they
one
were
said
testifying about zoning
yes.
issues.
No one said that I will speak on parking issues as well, because I want to go on the record opposed to this.
Sure.
Yes, I really do. I think that that's not very good that they get on these people. I'm going to figure out who they are, but these are brand new people in the community who have moved into Madison Avenue, probably haven't been here a year or so. We have all been here better than 35 years, and this house has been there. I remember when there were tenants in that house, but there was an owner person on the first floor, and it was only 3 apartments that was being rented. This new owner renovated the building with 5 apartments, and that is in total violation. I am an executive in a department, in a governmental department, that I promise you they are in violation with more than 4 apartments. They're in violation.
All right, Mr. Chairman, it looks like we have a couple members back. There is someone on the line. We had a technical issue with unmuting them.
Okay.
They wish to testify in opposition.
I've heard her speaking. I was here for most of that. I guess
want to go
one of the
on
questions I
record.
would, ma'am, hold on.
I'm sorry, sir.
One of the questions I would pose to you, Ms. Baumgartner, the individual is speaking in opposition to the application, closed that case out, and the applicant, went away so as not to be in a position to respond. But I think we can go on for purposes of the record. She had a technical issue. We have them get on, and I will say that the testimony will be limited to the issue that's before the board, which is the parking issue, and a matter for which we're not seeking duplicate testimony.
Yes, so let me see who we have back. We have the chairman, we have board members Strachan, Johnson.
We're going to have to go to the mayor. I'm going to have to do this. They are in violation.
Ma'am, you're
I'm
still
sorry. Oh, I didn't know that. I'm sorry. I'm sorry.
And we have board member Cunningham as well. So we have our 5 board members back. For the benefit of board members who didn't hear the chairman's earlier statement, we have a member from the community. We had a technical issue getting their testimony in, so we're going to open the case back up very briefly for 2020-61-2224 Madison Avenue to increase density from 5 dwelling units to 7 dwelling units.
That's what it says.
And ma'am, can you give us your name for the record, please?
Sure. My name is BJ Douglas.
All right. And Mr. Chairman, unless there's something else you wanted to add, we were going to open this back up very briefly for opposition testimony to the parking variance being requested under this application.
Very well. Thank you, Mr. Baumgartner. Go ahead, ma'am.
Okay. I am, first of all, let me say I'm opposed to the variance of having 2 additional parking spaces here or additional parking spaces here in our community. We have been here for a very long time. I don't understand someone who lives in this neighborhood who could even think that there's enough parking in the neighborhood, even for the people that live here now. I am also quite insulted that the zoning board put up a zoning sign and have a docket that says that these people are applying for 2 additional units to move it from 5 to 7 units. But when we get on the phone, you're saying it's just about parking spaces. Now, I've been in the city long enough to have seen some pretty tricky stuff that happens, and I don't want to hang this phone up and not go on record saying that that 2224 is in violation right now, having 5 units, but putting 2 more makes it further in violation of 504 laws.
And you're free, ma'am, to follow that, ma'am. You can,
Just may I please finish? May I please finish?
well, if it's
Given
irrelevant to
that
the issue that
the
that's before
parking
us, you may not.
spaces, well, can you address the reason that the docket says 2 additional units? And the sign that you put up for the neighbors to respond to?
Because that's what was requested under this application.
That's deceiving to the neighbors. Now, if you're only talking about parking spaces, it should say that on the docket. Now, we'll deal with the mayor and city council with the rest of this, but right now, we were of the impression that this hearing was about increasing from 5 to 7 units.
It's about increasing from 5 to 7 units because that's the request that's being made by the applicant. What that then triggers for purposes
just
of
like
zoning.
before when you were talking about the church, okay, it was a problem that they had the wrong request. So this is the wrong request. If
the request is what it is, it's a parking variance that is well within the scope of the board's decision-making power, and that's what we will exercise. With regard to the various violations that you're speaking about, we do not have that authority. That is not before us. We will not hear that. Is there anything else beyond what you said about parking?
No, okay, here's
Other than
about
it's not
parking.
enough.
Here's what I would like to see, sir. Someone on the board to specifically say this hearing is only about parking variances and has nothing to do with the approval of 7 units in that building.
This
When
hearing
we
is
were
about
offline, you gave me the impression that this was already approved. And I'd like to know what
No, we have not made a decision on the parking variance, ma'am.
So once you make a
believe,
decision on the parking variance,
ma'am.
Okay.
Let me speak. You've asked for
Okay.
a member of the board. I'm the chairman of the board. I would like to speak to you on the issue that you're raising.
Okay.
Mr. Baumgartner, on when we were offline, because I was present for that, explained to you that this individual, the applicant, could have 7 units as of right. Is that?
That is correct. That the density is determined by the lot area, and the size of the lot allows 7 units by right. That means that they would have to get a permit for 7 units.
Oh, okay. Okay, that's fine.
Many different requirements.
Now
For
that
the
I
purposes of
understand.
This hearing, ma'am, please stop interrupting everyone. For the purposes of this hearing, there are a variance requesting 2 parking spaces. That is why the sign says increasing from 5 to 7 units, because that triggers a parking variance. It does not trigger a density variance. That's why the chairman and the board are trying to get testimony from the applicant and from community members about the impact of that parking variance, because that's the only thing before the board.
Okay, all right, I respect that. After there is a decision on a parking variance, what does this decision mean today? That's all I'm asking. You see, there are people who were, and let me, may I say this, sir?
But you ask a question and then you keep talking. Okay.
Well, because you're interrupting me, sir. I'm trying not to interrupt you all, and I beg you
let me say this.
You
Let me say
didn't
this.
interrupt anybody who was for this. You
Ma'am.
did not. These people talked a long time. You never interrupted them one time.
Ma'am,
I'm trying to get my point
going around the
across,
same issue.
and
We will
you're
not go around
interrupting
the same
me.
issue multiple times. The issue is parking. It is before the board. The board will make that determination. Once the board makes that determination, that will be a record of the board's determination on the issue solely before it. If there are additional issues that you have that is not before the board, you have to take it up with the appropriate authorities.
Oh,
The appropriate
I thank
authority
you.
for the parking issue is the board. That's why we are holding the hearing. That's why we will be rendering a determination. There is no more discussion that's needed beyond the evidence that we need to render that decision. We believe we have it. We now believe we have your firm position in opposition to the parking variance that's been requested. That's it. We must move on to other cases at this point. Thank you.
Okay, and I thank you so much. You have a wonderful day.
Bye.
There.
Can we move on, folks? Everybody good?
Please.
All right. Case number 2020-67, 11 through 19 East Mount Royal Avenue, Adaku Onwuduwe,
Together in the hall.
to use lower level as educational facility, healthcare training programs.
They are on the line. Let me unmute them. Give me 1 second, Mr. Chairman.
Thank you.
Case BMCA 2020-67, you are live.
Okay, so you can hear me, right?
Yes, yes, ma'am.
Okay.
Ma'am,
All right, so I'm gonna-
hold on. We're going to get some staff reports first, if we have any.
Okay.
Nothing from Mr. Chairman.
Okay, Mr. French.
Thank you. The planning department reviewed this application, noted that this is a request for approval of a post-secondary healthcare career school. There is a requirement in the zoning code for off-street parking related to such a thing if it is classified as an educational facility, commercial vocational status, which would be 1 parking space per 4 employees on peak shift and 1 space per 25 students based on maximum student capacity. The information available to the department did not indicate either the number of employees on peak shift or the number of students maximum at any one time. Therefore, the department believes the applicant needs to work with both the fire marshal's office to determine the capacity for the space to be used, and then with the zoning board staff to determine any parking variance that might be required. Emphasis on might. The department has no conclusion at this point on whether there is a parking variance required. Property is in the Mount Vernon Historic District. Therefore, the department is recommending that if approval is granted, the approval be subject to the condition that all exterior changes, demolitions, alterations, and signage are completed or installed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation.
Okay, thank you, Mr. French. I don't know if I'm being heard because I can't hear anyone right now.
Yes, sir, you are.
You can hear me?
Yeah.
We can hear you.
Okay. With regard to the applicant, Ms. Onwuduwe, tell us about your project, and particularly explain the kind of healthcare training program you're intending to provide.
So I'm the owner of a nursing assistant training school. We've been in Baltimore since 2013. So right now we offer certified nursing assistant training. We do CPR training, and then certified med tech training.
Where are you currently performing it, or where have you been performing that since 2013?
We were at 19 East Fayette Street, and we had to move because the building got sold. So we went to, and they wanted to turn it into apartments. After that, we moved to 22 Light Street. But again, I guess it's what's going on downtown. We had to move because they wanted to turn that building into apartments.
Name of the
So
company.
go ahead.
I think I can kind of shortcut this appeal if the board would like. From that description, I believe this falls under the category of an educational facility, commercial vocational, and this property is in the C2 district, which would make that use a conditional use. So it is a type of use that would be allowed, and the board would merely need to find that the conditional use standards have been met by that explanation.
Thank you.
Very helpful. Thank you, Derek.
Thank you.
I don't know that I need to hear a lot more than.
No,
I think the only thing that needs to be addressed quite frankly, is what Mr. French said regarding parking. Because there
So
wasn't.
there is, okay. So on average, we typically have anywhere from 6 to 10 students at a time, and then an average of 1 to 2 employees, most times just 1 because I'm the teacher, at a time.
And ma'am, is there anywhere on site to park?
On site, like street parking?
No, like on your lot.
Well, there isn't, it's not really on a lot. There's lot parking that is available, but it's not like on the same lot as the actual building. It's like a private lot that's
like
maybe like a
parking?
2-minute walk.
Okay. Have you made any effort to contact that owner to see if you can reach some kind of lease?
Yeah, so the cost to park is $150 a month, but I found a parking garage. It's like a 3-minute walk. They were able to give us a discounted rate from $11 a day to $4 a day.
And would that be for how many spaces, or just like however many you had needed?
They didn't limit me. They just wanted to know on average how many people will be parking a day, and I told them between 8 to 10.
Okay. Thank you.
I'm good. I don't have anything else.
Okay, do we have any further questions?
No.
All right, great.
One more
Thank
thing. In regards to parking, I mean, there is metered parking available at 50 cents an hour, and then maybe like 3 blocks up, there's parking for free, like on North Calvert Street. So there is available street parking.
Okay. Thank you very much, ma'am.
Thank you for your presentation, ma'am.
All right.
Moving on, we're going to call the case of 2020-77, 2511 Chelsea Terrace. Lisa Tate, to use the first floor as 15-child daycare center.
I find Ms. Tate. Is Ms. Tate on the line, or someone who's going to be speaking with her, or speaking for her, rather? I'm seeing no messages in the chat space. Looking at the Q&A, I don't see a Lisa or a Tate or anything by that name. So Ms. Tate, are you on the line? And that's a no response, Mr. Chairman. If we could call this case back at the end of today's docket.
All right, we'll call 77 back. By the way, we called 74 back. Still didn't get a response. That was a consent matter.
Yes, sir.
All right, we'll keep moving. Calling case number 2020-79, 3205 Bella Road, Steve Kong. Use first floor portion known as 3207 Bella Road as community center.
I see Mr. Kong here. I am adding him to the list. He should be available momentarily.
I'm here.
Okay, let's get the staff reports if we have any for this property.
Thank you. Planning Department reviewed this application, noted specifically what it is requesting is approval of, and quoting here, STEM projects, community meetings, training sessions, MMA training, and more, end quotes. Know exactly what MMA stands for, but it may refer to mixed martial arts, since the department staff have heard that term used that way. If that is the case, the applicant should provide the board information to clarify that martial arts instruction would not cause the proposed use to be categorized as a type of commercial educational facility, Educational facilities, commercial, vocational, are prohibited use in the C1 zoning district where this property is located. The urban renewal plan for this area does not prohibit the proposed use, however. The department has no objection to the application if the applicant demonstrates that to the board that the proposed use would not be a commercial educational facility. Thank you.
Thank you. Mr. Baumgartner, there's nothing from you on the.
That's correct, Mr. Chairman. We don't have anything that I'm aware of from the community on this one.
Okay. Mr. Kong, tell us about your project, sir.
Actually, if you can put up Michael John, he's a tenant that's doing the project. He will explain everything better than I can.
Sure, I found him and I have unmuted him.
Okay.
Mr. John, Michael John Jr. Mr. John, Michael John Jr. Mr. Chairman, he's unmuted in the panelists section.
Okay. Mr. So, Mr. John is present or no?
From my end, he is, but he's not responding. He's raised his hand, but sir, you are unmuted, so you should be able to speak.
That he's here.
Yeah.
Maybe we can't hear him.
So he's definitely here, and my thinking is that he might be like on his end, so not through what. So not through what.
I'm going in and out. So take the testimony, please. I'm going in and out. And I can't tell when the audio is going to stop.
Sure. So, Mr. John, this is Derek Baumgartner from the board. I see your chat message. We cannot hear you. So I can see your chat message, and from your message, that means that you can hear us. You provide the board with an understanding of the proposed use in the building. So can you list for us the types of activities that will be occurring in this community center? And you can include that in the chat feature as well, and then I can read that to the board. And for all board members, isn't technology grand?
Love it.
So we'll give Mr. John another couple moments to respond either in the chat feature or to see if he can be present. If not, I would recommend adopting the planning department's recommendation that we simply, on the community center use, we include that in the board's decision if it's approved, to limit it to the things that have already been requested.
Sounds great.
Me.
I'm good.
Okay.
Sounds good.
All right. Well, Mr. Kong, thank you.
Thank you.
So we do have, we do have a message from the Bel Air Edison neighborhoods. Angela, let me see if I can, here we go. And Angela, I apologize, ma'am, if it's Akes or Akis. I'm going to unmute you now, and you can, I think we have some opposition testimony.
Okay.
Hi, my last name is Akes. I'm the Main Street Director for Bel Air Edison Main Street. We have been working with Michael John and Steve Kahn on support of the project in the 3200 block.
Great.
The 3200 block is one of my most troubled stretches on our Main Street. It's been known as an open air drug market, for less than better words. This program, which show is going to pull youth directly off the street, right into Michael's program. The community has already demonstrated support in the project. The discipline and structure will be greatly appreciated in the corridor as we look to outreach into youth engagement, other initiatives. Michael John's as well as Steve Kong's support has been huge to Benny. We will take the recommendations and make the necessary changes and update and re-support.
Thank you.
Submit.
Great. Thank you very much. All right, I'm not seeing any other raised hands. Let me go back through just to make sure. Yep, I'm not seeing any other raised hands for testimony for this particular case, Mr. Chairman. Mr. Chairman, are you back with us, or are you still?
I am. Can you hear me?
Great. Yes, sir.
Okay, great. All right.
So that is all we have for that case, I believe.
Okay, thank you. Moving on, calling the next matter, case 2020-80, 157 South Augusta Avenue, Pamela Mason. We erect approximately 200 linear feet of fence, 5 feet in height around the perimeter of the property. Do you have any staff reports?
Nothing from my side.
Planning Department has no comment on this application. Thank you.
All right. I'm taking Ms. Mason off mute now. Ms. Mason, you are live.
Can you hear me okay?
Yes, ma'am.
Okay. I don't have anything other to add, other than the front fence, the area going towards Augusta Avenue. I have changed that from 5 feet to 3 to 4 feet instead, and probably about what is there now. The fence is going to be it's not going to be a privacy fence. It's going to be a see-through fence type fence. So I don't see any problem with it. If there's any questions, I don't know what else to say.
I mean, you said it's not going to be a privacy fence. It's going to be a what kind of fence?
It's going to be the kind that look like bars. It's aluminum fence, like black bars that you can see through.
And ma'am, what is the purpose of the fence?
Okay, right now I have chain link. Okay, that's a 3 foot fence. I'm asking for a 5 foot. The purpose mainly is that I have a dog that can jump that 3 foot fence. Okay, so that's for the backyard area. That's why the backyard is going to be 5 foot. The front yard is going to be, like say, 3 to 4, just to keep people from cutting, because I live on the corner, so I keep people from cutting across my yard. That's the purpose for the front of the fence.
Okay.
Well,
thank you.
Thank you, ma'am.
Thank you.
Okay. Next case we have is case number 2020-84, 107 West Clement Street, Dan Barron, to construct second floor overhanging rear addition and new third floor.
So, Mr. Chairman, we have several letters in opposition. We also have at least 1 or 2 letters in support of this appeal. The Planning Department has any further staff reports?
Planning Department has no comment on this application. Thank you.
Thank you, Mr. French.
Mr. Chairman, I see Mr. Barron is logged in. I believe he's represented by counsel as well. So I will unmute both the applicant and his attorney to give their presentation. And then after that, we will move on to any opposition or support after that.
Good afternoon. Can you hear me?
Yes, sir.
All right. My name is Abdullah Hijazi. I'm attorney for the applicant Income One LLC and their representatives Dan Barron and Garrett Adler. My address is 3231 Superior Lane, Suite 826 in Bowie, Maryland, 20715. With me today, I have 3 witnesses. The first witness is a neighbor that lives a half block away, Mr. Kevin Gracie. He has already submitted his testimony in support of the variance by email, and there's no need to have it heard again live unless the board has direct questions for him. Additionally, with me are Mr. Garrett Adler, a representative of the applicant Income One LLC, and the owner, which is the owner of the property, and the third witness is the architect of record, Mr. Elijah Northern. They will both testify as to the need for this variance and the practical difficulty that the applicant will face if the variance is not granted. The applicant is only requesting a variance from the 20-foot rear yard setback required in the R8 zone. This is only for the second floor because of the narrow nature of the home. The home was originally built in the year 1900, and the first zoning code in the city was not passed until 23 years later in 1923. Without the variance, the applicant will not be able to have a covered parking area in the rear of the home, and more importantly, will likely not have a fully usable second bedroom on the second floor of the home, which will leave the home with only one practical or usable bedroom. We are requesting a variance to reduce the required 20-foot rear yard setback to 12 feet. And that 12 feet is only required for the second floor because the first floor does comply as proposed with the full 20-foot setback. Originally, the home only had a 7-foot setback, so the applicant has already made it better by bringing the first floor into full compliance and is asking for a approval on a variance to allow the setback for the second floor to be 12 feet instead of the required 20 feet. Now, there are many equities at play here as well, in addition to the hardship. This home will be the only home on the block or in the 2-block radius that will, if the variance is not approved, will be forced to comply with the rear setback requirement. All of the properties between 101 West Clement and 135 West Clement, which is 18 homes, all on the same side of the street, do not currently comply with the 20-foot setback. And many have already been approved for variances by this board for the setback and other configuration issues because these homes are very narrow. The interior width of this home is just above 11 feet wide. The owner, as I said before, has already brought the property into compliance on the first floor, and it needs the variance for the second floor. The rear portion of the second floor has also been demolished to shave off about, let's say, 5 to 6 feet, bringing the setback into 12 feet at this point. The home, as it stands, will have the largest rear yard setback in the block. We have submitted by email to Mr. Baumgartner a set of exhibits. One of them is a diagram that shows all of the surrounding homes and their approximate setbacks in comparison to the home on this block. If you review that exhibit, you'll also see that a few of the homes in these 2 blocks actually have no rear yard setback whatsoever. For example, 101 West Clement, 113 West Clement, 115 West Clement, and 135 West Clement all have almost a 0-foot rear yard setback. So this property provides the required 20-foot setback on the first floor and only needs a variance to bring the rear yard setback down to 12 feet for the second floor. And in fact, as I said, most of the homes, or actually all of the homes between 101 West Clement and 135 West Clement on one side of the street do not currently meet this zoning code requirement, which was enacted at least 23 years after most of the homes were built on this block. At this point, if the board doesn't have any questions for me, I'd like to present Mr. Garrett Adler as a witness and ask him a few questions so he can have a chance to testify in support of his application.
Mr. Chairman, I'm unmuting Mr. Adler right now.
Mr. Adler, are you there?
Yes, can you hear me?
Yes, we can hear you. Could you please spell your name for the record?
My name is Garrett Adler. That's Garrettadler.
Mr. Adler, how are you affiliated with the property owner?
I am a member of the LLC that owns the property.
Could you briefly describe the subject property at 107 West Clement in relation to the surrounding neighborhood?
Property was built around 120 years ago based on my review of the public records. It is very narrow, and our proposed plans will actually make it the smallest property on the block and will provide the largest rear setback on that particular block once we're finished construction, hopefully. We are actually reducing the existing setback as we achieved a permit and did some demolition to actually expand the setback that has been existing for some time that we can't determine.
And will Income One LLC suffer practical difficulty or substantial hardship if the variance application is not approved today?
Yes, yes, we will, because it'll be very difficult for us to get more than one functional bedroom in the house, and we won't be able to get a covered parking area in the back of the house, which is what we're looking to do. If the variance is not approved, the home will likely be very unattractive and unmarketable to a family with more than one young child, because the second bedroom on the second floor would be very small.
Before or after filing for the variance request, have you reached out to neighbors in the immediate area to see if they have any concerns or tried to address neighbors' concerns?
Yes, I have. The majority of neighbors, to my knowledge, are very happy that we were renovating this property because it was an eyesore and, in fact, a hoarder's area. So we did extensive clean out of the property already. In fact, Mr. Gracie, who lives about a half a block away from the property, wrote an email in support of our variance that I believe you have a copy of. We have only had opposition and some complaints from one of the immediate adjoining neighbors, even though our home provides a setback that is much smaller than the variance we are providing. And her home has been previously approved for a variance to allow this very small setback that she has. In fact, her second and third floor both extend to about 6 feet from the property line, as you may see in the diagram that was provided. We are only requesting a second floor overhang with a setback of 12 feet, so set in considerably from where the neighbor's house actually is extending to.
And did you reach out to this specific adjoining neighbor to try to address her concerns before the hearing?
Yes, I actually offered a meeting on site in the alley to discuss how we could move forward amicably. She refused that request. And then at her request, we had a meeting via Zoom with her and actually the council member for that area, Eric Costello. And when we all were on the meeting and looking at each other, she complained and said that she needed it to be recorded. Otherwise, she was not going to speak with us. And nobody agreed to have it recorded. So the meeting signed off without any actual words being spoken. I believe you, as our attorney, has reached out to her also actually a few days before the hearing, and she refused to speak to you without having that recorded and said she would address her concerns here at this hearing. I believe I've done everything. Sorry, go ahead.
No, go ahead. Please finish.
Okay. I believe I've done everything I can to address their concerns, which I have yet to actually hear what they really actually are. And I've really, tried to make her happy, I guess, but she won't speak to me. We haven't had any conversations really with her at all thus far. She has definitely spread rumors about me and made false allegations on social media. Has been particularly nasty, and I don't really understand the reason for the vitriol, but I'm hoping that we can move forward from this.
Mr. Hijazi?
Yes, Mr. Brungarner.
Can we keep testimony directed towards the appeal, please?
Yes, we'll do.
Thank you.
So did you prepare the exhibit showing the rear setbacks for the properties between 101 and 135 West Clement and labeled them with their previous variance case numbers?
Well, I labeled them the variance years, the year that the variances were.
Okay. So do you believe that that exhibit is accurate and true to a reasonable degree of certainty?
Yes, I do.
And did you take the photos in the rear alley behind the property showing the distance between the rear property lines and the adjoining homes surrounding this home?
Yes, I did.
And I'm specifically referring to the 3 photos that were submitted into the record.
Yes, I submitted those showing that all of the homes are not actually adhering to the 20-foot setback. In fact, they're very close to the property lines, and what we're looking to do is less than what everybody else has done. So we're just hoping for that respect.
All right. Well, thank you for your testimony, Mr. Adler and Mr. Baumgartner. That's all I have for Mr. Adler. If the board or you don't have any other questions, we'd like to have Mr. Elijah Northern, the architect of record, go live at this point.
Sure. You find him?
Please tell me he's there.
Mr. Baumgartner, do we?
Yes, sir. Mr. Chairman?
I think he may be asking whether or not you swore the witness in.
We have not sworn the witness in, but we can certainly take notice that this is a quasi-judicial hearing, and that all testimony provided in the quasi-judicial hearing is required to be truthful.
Okay. Well, he can be sworn in, and at this point, if you'd like. But
Sure.
I don't know if Mr. Fields is still muted.
I can hear you now.
We can swear future witnesses if you'd like, Mr. Chairman.
I'm sort of at a loss because I don't know what you said before that. So
I'm sorry. I was saying that in a quasi-judicial proceeding, there's sort of a presumption that what is being spoken is truthful. We typically swear witnesses when we have everyone in the same room. Doing so in a virtual hearing for every single witness would be problematic. But we can certainly swear in individual witnesses at this point if the board would find that helpful. So Mr. Jazzy, he's calling his second witness, which is Mr. Northern, and he is here. I can unmute him and swear that witness if the chairman would like.
well, actually, I thought we were proceeding, and I didn't make it clear that we were proceeding that to the extent parties present witnesses for testimony that they would all be testifying under oath, as if the oath was given formally as it would be if we were in live and in person. So that's how we are receiving this testimony, and any witness testifying should govern themselves accordingly, and presume and believe and intend to provide truthful testimony under the penalties of perjury.
Yes, sir.
I don't think we need to have them separately sworn. I think I lost you again. But I think we can proceed, and we're accepting the testimony as if it's under oath.
All right. Unmuting Mr. Northern.
All right. Can you hear me okay?
Yes,
Yes,
sir.
All right.
All right, Mr. Northern, can you spell your name for the record, please?
Sure. Elijah Northern, ELIJAHNORTHEN.
And Mr. Northern, how are you affiliated with the project and property at 107 West Clement Street in Baltimore, Maryland?
I am the architect. I was hired by the owner to create permit drawings for the project.
And can you briefly describe why the applicant is in need of this variance?
Sure. I think you filled in a lot of the pieces, so I don't need to rehash all that. But one of the things early on when the applicant and I were investigating, he did actually charge me with trying to conform to the setback. So that was something that we did explore. It wasn't just sort of anecdotal. We explored that, and the owner was determined to try to comply with it. But after several tries at floor plans, as you mentioned, we were at a loss to determine how we could possibly fit in a full second bedroom, full bathroom, and the property would have been reduced to the point, in my belief, from working on a lot of these properties, would have been reduced to the point that it just wasn't viable as a house on this block in this market.
And have you seen the diagram of the properties between 101 and 135 West Clement Street that was prepared by Mr. Adler?
I have, yes.
And do you agree with, or generally agree with the setback measurements and the descriptions shown in this diagram?
I do. Well, I haven't measured them individually, but from being at the property and looking at the diagram, it looks very accurate.
Okay, and do you believe that the applicant will suffer a unnecessary hardship or practical difficulty if the strict letter of the rear setback requirement for the R8 zoning is required in this instance?
I do, and as I mentioned, and I think you mentioned as well, in this neighborhood, I just don't believe we can create a viable house that's marketable and that can sort of retain its value, and so we didn't see any other way but to apply for the variance.
Okay. Are the conditions of the property unique to this property and not generally applicable to most other properties in the R8 zoning?
They are. And one thing that we assessed early on in the project when we walked through with the owner was that the existing rear addition, as you mentioned, was only about 7.5 feet off the rear property line. And the house being 11'8", the addition also stepped in from the party wall. And so that addition was long and it was narrow. It was probably about 7.5 to 8 feet. So it just wasn't viable. And to my, I'm not a structural engineer, so I didn't run calculations, but as an architect, to my trained eye, it looked as if it was not suitable to be sort of reinforced and reused, and that it needed to be removed.
And has the unnecessary hardship or practical difficulty in this case been caused by the code and not by any intentional action or inaction of the applicant?
It's the code, and as I mentioned, the applicant we tried together to try to design within the code, and we didn't find that we could create a viable option.
Okay, so would you agree that the purpose of the variance is not based exclusively on a desire to increase the value or income potential of the property?
I wouldn't say so. No, I think it's just to create a realistic outcome.
Okay, so the applicant is not exclusively basing this request on the desire to increase value or income potential?
No.
Okay. And will the variance be injurious or to any properties or neighbors, or adversely affect or injure any adjoining properties or neighbors?
No, I think if anything, it will have the inverse. I think it's creating a beautiful property where there was, something vacant.
Yeah. Would you also agree that it's bringing the property into further compliance with the code by increasing the rear setback?
Absolutely. I mean, the rear setback on the first floor, as you mentioned, is compliant on the first floor, and we're really only talking about the second floor, and we're substantially more compliant than any other house on that block.
Okay. So will the variance decrease the value of any of the neighboring properties?
No, as I said before, I think the inverse.
Okay. And is the variance in harmony with the intent of the Baltimore City Code?
Is the variance in harmony?
Yes. The variance request, is this in harmony with the intent of the Baltimore City Code?
Yes.
And do you believe that the variance will preclude or adversely affect any city urban renewal plan, comprehensive master plan, or any historical and architectural preservation district guidelines?
No, if anything, it'll enhance.
And lastly, will the variance be detrimental to or endanger the public health, safety, or welfare, or be in any way contrary to the public interest?
No, in fact, I think it's the inverse. You're getting another car off the street, and you're bringing it more in compliance.
And that's all I have for you, Mr. Northern. I really appreciate your time.
Thank you.
Table back to Mr. Palmer.
Thank you.
All right. So Mr. Northern has been muted. Mr. Hijazi, was there a third witness or? Yes.
The third witness emailed his testimony in. That's one of the witnesses I think you referred to, Mr. Kevin Gracie. I'd also request that all of the exhibits that I emailed to you ahead of the hearing be put into the record. For reference, it was 3 rear yard photos of the adjoining houses and this house, and then it had the diagram I referred to showing all the houses between 101 and 135 West Clement Street and their rear setbacks. And then I believe we had a copy of the plans and the 3 posting or 2 posting photos in the posting affidavit to be on the safe side.
And those have been received.
I appreciate it. Thank you and the board for your time, and I'd be happy to answer any questions if there are any from anybody.
I'm good.
I have no questions.
Mr. Chairman, we do have at least one member of the community to testify in opposition. Let me. Ms. Waite, I'm sorry, Ms. Burgos, you are live.
Hello. I don't see us. Oh, there we are. Hi, it's actually Dr. Waite and Mr. Waite. Thank you for having us and hosting this board, and we'll try to get this done as soon as possible as we approach on the 5 o'clock hour. I sent over an opposition testimony to Mr. Baumgartner. Thank you. Has that testimony been available to the board in general, or?
When did you send that, ma'am?
I sent it to you on Friday morning. Did you receive it? So the board has not received my testimony that I sent to you Friday morning.
I'm looking. Here it is. You may testify to its contents. It looks like it's about 3 paragraphs. You're welcome to testify to the contents of that email.
No, I sent you a PDF document. I can read it.
Sure.
It's more helpful if the board had the images that were attached as I referenced them in my testimony.
I don't have any. I'm looking for. All right, let's see here. But please move forward with your testimony, ma'am, and I'm trying to find it.
All right. Andy, you were CC'd in that email. Would you mind actually just resending it to him? And I have acquired Martin French's email and Marsha Middleton's emails right here, and you can send them as well. And let me just see. Now I'm trying to see if I can copy and paste it into the comments, but that's not working. All right, well, I'll just start. I'm in opposition.
Go ahead, ma'am.
We would like to first thank the board. And in regarding to the matter of permanent approval for constructing an addition at the rear second floor of 107, we believe that a permit should not be approved as current drawings and proposed building methods are not following proper codes, are inaccurate to the drawings that he provided, and ultimately will be illegal. And I know that mentioned earlier in this hearings is a conflict between what is required by the zoning board and what is required by the city board. And I would just like to state that according to the zoning code of Baltimore City, under section 1-204, conflicting provisions, item B, most restrictive provisions governs, it states that if any condition or requirement imposed by this code is either more or less restrictive than a comparable condition or requirement imposed by any other provision of this code, or any other law, rule, or regulation of any kind, including an applicable urban renewal plan, the condition or requirement that is more restrictive governs. So, in my first point of not following proper codes, the proposed second floor addition at rear is unsafe and will pose a safety hazard to our home, our neighboring adjoining homes, and the future inhabitants of that home. The proposed plans do not include any structural analysis, as Mr. Northam has already said. He is an architect and not a structural engineer. And the proposed do not include the, as per the existing building code of 2015, Maryland section 1401.41.1, which states that a structural analysis must be required. I will save you the time in reading the whole code, and I hope that Mr. What's his name? Baumgartner actually finds my testimony and emails it to you guys.
Ms. Burgos, I don't want to interrupt, but you're correct in your statement about the more restrictive provision governs, but that's only with regulations that the board has jurisdiction over. So the board does not have jurisdiction over the building code. So items regarding safety, structural integrity are not within the board's discretion. And they're not things that the board can hear. So what's helpful for the board is to understand your opposition with respect to the zoning issues of this case. So will it block light and air? Will it depreciate your property values? What's the zoning impact of the proposed addition to you?
Well, it affects me in several ways according to the zoning. And I'll go on to then section 2, which is inaccurate drawings. But I still hope that you guys read, because I think that the structural analysis as this permit, I know that you guys are not going to regulate it, but if this permit is approved during this board hearing, it will lead to construction. And without these analysis, will make the foundation unstable and could lead to collapse of our homes, putting everyone in danger. So it's kind of a big safety issue. But in regards to keeping it focused on the zone, it is inaccurate drawings that the plannings you guys have received. And maybe they're different from the plannings that I received from Mr. Baumgartner earlier in the month, because maybe plans have changed. I know that on the docket, it now says a 3rd floor addition, which was not on the plans that we had received. So maybe things have adjusted, but according to the drawings, they're trying to use this variance that they will be constructing and then will be extending to the full length of their property line, but then they'll be crossing our property line and flashing to the side of our 3-story house, which, 1, we haven't approved of them to do that, which is kind of illegal, and 2, it will then be blocking sunlight and air from an area, like Mr. Northern said, that the original outline of the house was stepped in from the property wall. There is now I guess like a half sally port there, and that area is going to be completely encaged, creating a nest for roaches and mice to then go and infest that area. That is a serious public health concern. Pests have been known to be allergens and can, be allergen drivers and increase asthma morbidity. So as the architect had said, he's thinking about children. Well, children and asthma in Baltimore City have a history. And so let's try to make this as the cleanest, building structure as possible by keeping that gap intact. So, and then I mentioned that they will be flashing to my house, which is illegal, as I have not given them permission, our house, to do any kind of work on our property. So they may construct as they please in terms of extending to the full width, but I really highly suggest that they build with other materials other than an infill wall, so that they are not required to then reach over the property line and do work on our house, which we have not approved.
And then, are you saying, hold on, are you suggesting that this construction is going to require the builder to work on your home?
Yes, the way it is currently.
In what way?
So they will have to remove my siding, as my side is completely covered in exterior siding, to then flash their roof line to our house to make that infill wall that they are constructing an exterior wall. Currently, the material that they're using is not appropriate for a standalone exterior wall and needs to be covered by the roof. And that roof, since it is, needs to be flashed to my house, they will need to remove my siding, cross that little line, and then actually do work on my house in that manner.
So I have a question for you also. You have a 3-story house and you don't want the house next to you to also be 3 stories?
No, we have no problems with how high the house goes. We just wish that they conduct their construction within their own property lines and don't work on our house in areas that have historically been detached.
Are your houses connected on the 2nd and 1st floors already?
Yes, on the front half of the house is connected by a party brick wall that has been there since the house was built, and and the rear has been detached. So when they mentioned that our variance was constructed whenever, I think in 2005 is when they renovated, we were juniors in high school. They built our house, but because the house 107 was still with the original outline, it was still stepped in from the party wall. So there was a gap there that has Sally Porter detachment, and we would just like to keep that detachment intact.
So as far as you know, your house was given a variance to do something similar to what they want to do to this house. It just was done while you were in high school instead of while you were an adult homeowner?
No, it's different because it wasn't blocking that light in that gap area, and this variance will block that light in that gap area. And like I mentioned, it will increase the I guess, pest and roach infestation, creating that cave environment that I mentioned earlier. So my house kept that gap intact, letting ample light and airflow and maintenance of that, detachment area, versus this variance will make it a cave. And so that's what we're in opposition.
The appellant at all about what they're planning on doing? Have you expressed your concerns to the appellant?
Yes, we have emailed them, and in the testimony, which Derek, have you had any chance in passing it along to the rest of the board members?
Yes,
Well, we'd rather you're here now. You can testify, and we don't frankly have the opportunity to read that. So it'd be better if it comes from you so we can follow up with questions.
All right, okay. We emailed them on March 19th because they had told us that that was their proposed plan, and I thought about it for a while, thinking that they were going to approach us with a formal, kind of proposal saying, hey, we will need to attach to your house based on our building plan. So we kind of just let them talk and we waited. But then on March 18th, we noticed that they started constructing in a manner for which attachment will be inevitable if completed. So we emailed Matt Reamer for GRM, the contractor, letting him know that we hope he's well and safe in the pandemic, but that we are not authorizing any attachments, including flashing. The email's a little hot and spicy, at which point Garrett Adler emailed us back, I'm writing to request you cease and desist any further harassment of our contractors with regard to the construction project. He said this again, there's some other issues that we've had with part of their exterior building is crossing that line now and pressing up against our siding, which we let city officials know. And we emailed Garrett Adler, and he again said just to stop and harassing us and cease and desist your contact with us, which is confusing since at the beginning of the project, we had gotten their card and a letter saying, call us if you have any concerns. But when we reached out, we're getting, you're harassing us and desist. And that's why later on, when they want to mitigate issues and they're contacting us, we request that any communications we have them be on the record. I'm opposed to this variance. I think that it will create a blocking of that light and airflow and create a den for pests and roaches, increasing asthma drivers, and it just will depreciate the value of the home. No one wants to buy a roach-infested home to an area that they can't reach or have access for maintenance.
Anything else, ma'am?
I would like to say that if my testimony does reach you guys, we did add that we had concerns that the docket was different from what the sign had posted. And sitting through the hearings today, I just would like to, it just felt good that we weren't the only ones that were confused as to signs posted and then what's actually on the docket. So, yeah.
What's the basis of your confusion? What don't you understand?
The docket had only said that it was for a addition at the second floor addition. That was the sign. And the docket says this new third floor. And so the basis of my confusion is I wasn't aware that this third floor did not need to be a part of this hearing because it appeared on the docket. It almost implies that it will be part of this hearing and therefore will subject to the 21-day notice rule, and there lies the confusion. So if you guys ever do get my testimony, disregard that statement.
Okay, anything else?
Anything else? And then just that the architect had mentioned that he thought about different ways to build. Another thing we're concerned about is that the proposed plans for the second addition don't include any chases.
Mechanical chases.
So right now, according to the planning, there is no space for HVAC or plumbing to go, and we're concerned that this will lead to building HVAC and plumbing in between the walls of the two townhomes, which is a code violation. That's it. I'm a little bit disappointed that I wasn't able to read my entire testimony, but I understand that time is an issue, and I really hope that you guys get it.
Ms. Burgos, we do have your testimony. It's been forwarded to the board members. Well,
Perfect. I would like to add it. I'd like to make sure that it is included in the record. I think that's what you're
correct. So
supposed to
everything we received is included in the record. But what the chairman was getting at is we're, again, with many appeals, it's what's relevant to the issues before the board and what's irrelevant. And a lot of your written testimony dealt with, building code issues. And as we spoke of before, those are just aren't relevant from a zoning perspective. They're certainly relevant from a building code perspective. But that's why it's important to have live testimony like here today, so you can explain the zoning aspects of your opposition. But all your testimony is included in the record and will be and is in the file right now once I can get to the office to physically put it in there. But just to make it clear, everything we receive goes in the record.
Okay, great. I think that's it. I don't know, this whole experience has been testing, and I hope that, I don't know, I think that there's a lot of homeowners in Baltimore that can't afford lawyers to protect themselves and look to city officials to kind of defend their property rights. And I hope that this testimony serves to shine a light on issues that I have highlighted in my testimony so that things can hopefully go in a different direction moving forward.
Thank you for your assistance. Thank you. I don't know if counsel for the appellant had any questions of this witness or I'm sorry?
I just have two quick questions for Dr. Waite. Dr. Waite, can you hear me?
Yes, I can hear you.
Well, first of all, I want to thank you for your testimony and you spending time today to come out and testify as to your opinion as to the variance request. My question to you is, what is your doctorate or educational background in?
I have a doctor's degree in veterinary medicine and a master's degree in public health. I currently work at Johns Hopkins School of Public Health conducting research in the One Health field, looking at different areas of emerging diseases.
Okay, so you are not a structural engineer or a construction professional of any sort?
Nope, I'm just a homeowner who's concerned about construction in the adjacent home.
Okay, well, I appreciate your concern. That's all I have for Dr. Waite, but I'd like to make some closing remarks if the board will allow.
Yep. At this point, we'll go back to the applicant and counsel. You may proceed.
Thank you. So again, Dr. Waite mentioned section 1-104. That section of the code is not meant to wipe out the variance part of the Baltimore City Code. Secondly, the safety and structural analysis issues are not before the board. In fact, these are issues that would be reviewed by the city in the during the permitting stage and during the permit inspection stage. The mention of the third floor, I know on the docket is confusing, but there is no variance required for the third floor. The third floor is a very small penthouse in the middle of in the middle of the home, and it requires no variance. The variance is only needed for the second floor. As to the points brought up as to the air and the sunlight, the neighbor is saying that the variance will block sunlight and air, but that is not true. In fact, the property was only providing a 7-foot setback, and as proposed, will be providing a 12-foot setback. So, if anything, the side of the house will get more air and more sunlight, especially if there are windows in that area. Now, as to the rodents and infestations and cockroaches brought up, I mean, to me, this is a very frivolous claim, but nonetheless, I will respond to it. When you leave a gap between the two homes, that is what will lead to infestation, an area that will lead to an area that will house and breed such rodents and bugs. But by sealing the party wall, which my client has full, allowance and legal right to, his party wall along the adjoining property owner's party wall, then that will prevent there being any gaps in any area for such rodents or bugs to infest in the future. That's all I have in response to Dr. Waite's testimony. Again, I and my client and Mr. Northern, the architect of record, are more than happy to answer any questions that the board may have at this time.
Any questions from the board at this time?
No, no.
Great. Thank you, sir, for your presentation. I think that
Thank you all
concludes
for your time.
this particular matter.
Thank you all for your time. Thank you, Mr. Chairman.
Thank you. Moving on to next case, 2020-87, 626 Dover Street, Justin Hines, to erect approximately 30 linear feet of fence, 8 feet in height in rear yard. We have a staff report with regard to this property.
Nothing. My department has no comment on this application. Thank you.
Thank you, Mr. French.
Hines is right here.
Yeah. They didn't.
And Mr. Hines is here. I'm going to unmute him. Mr. Hines, you are unmuted.
All right. Can you hear me?
Yes,
sir.
All right. I guess the first thing I'd like to note is I think the address that was read off might not be correct. I'm at 626 Dover Street.
Okay. I'm sorry. What did I say? I meant to say Dover Street. That's what it says. I apologize.
All right. I'm sorry. Maybe I misheard too.
I don't know. Do you want to stick around?
Nah.
Go ahead, sir. Tell us about your project.
Oh, it's very basic. I live in a row home,
Yes, sir.
3 homes to the right and about
The light will actually.
5 or 6 to the left. And I want to replace my fence in the backyard with an 8-foot fence. Right now there's a 6-foot fence there, and I just want to put an 8-foot fence in there. I've had some problems with people trying to climb over, which has partially broken the wooden fence that's there right now. And I had some people trying to break through the gate that's there. So it's in bad shape. It needs repair, and I figure I'd just replace it with something that's a little bit taller.
Okay, so the fence you have presently is a wooden fence?
That's correct.
And what material do you intend to use for this portion of an 8-foot fence that you'd like to have? Still wood?
It's whatever the common vinyl fence material is.
Okay.
And Mr. Hines, in the rear of the property, there's a public alleyway there, correct?
There is. It's about 4 feet wide.
So it's not like for vehicles. It's only for pedestrian use.
I'm not really sure what it's for. I think it's like fire access or something, because pedestrians really shouldn't be back there either.
And then what's on the other side of that? I guess we'll call it an alleyway.
It's a parking lot for an Ethiopian restaurant, and it's also shared with the Babe Ruth Museum, which is right around the corner. But it's elevated, so it's like a foot or two higher, actually. So, like if there's a 6-foot fence on their lot, like it's way above where my 6-foot fence is right now, because it's just elevated.
Got it. Okay.
Okay. Are there any questions from the board at this point?
No.
All right. Mr. Hines, thank you for your presentation.
Thank you.
Okay. Go on to case that was taken off of consent, 2020-88, 2763, the Alameda, Jonathan Walcott, seeking the continued use of the premises as 2 dwellings.
I'm going to try to find Mr. Walcott.
Mr. French, do you have any staff reports associated with this property?
Yes, sir. This particular property is located in the Coldstream Homestead Montebello Urban Renewal Plan area, also the Coldstream Homestead Montebello National Register Historic District. In the context of community planning and revitalization, there is a Coldstream Homestead Montebello area master plan adopted in 2006. which includes guiding themes relating to housing in the CHM, Coldstream Homestead Montebello area. These call for action to increase opportunities for home ownership, encourage rehabilitation of vacant homes and new construction throughout the area, and encourage rehabilitation and preservation of the existing stock, meaning housing stock, in areas of strength. Overarching goal of the CHM master plan is to maintain a strong base of homeowner occupants. This application has a blighting influence on its block, and this block and surrounding blocks have been identified by the Baltimore housing market typology as market level I, meaning strong owner occupancy level, but experiencing pressures on home owner occupancy that are caused by higher than average rates of foreclosure and vacancy. Permitting division of a vacant, originally single-family row house into 2 dwelling units, at least one of which would be a rental unit, would be contrary to the community's plans and efforts to increase its proportion of homeowner occupancy. Given that the applicant may have held this property in vacant condition for at least 8 years, based upon the information about the ownership of the property, the community is desirous for its being promptly returned to habitable condition and would prefer that it be restored to its original single-family condition. The department is recommending disapproval of the application on the basis of its incompatibility with plans and redevelopment strategies for the community in which it is located. However, should the board determine that this application is approvable, the department further recommends that approval be subject to the condition that the property is certified as being in habitable condition by issuance of its use and occupancy permit within 12 months of the board's approval. Thank you.
Mr. French, this is
Yes.
Derek. Do you have in your records whether or not the property currently has a use as a single-family property?
This property was based on the record available to the department, was approved for a multifamily dwelling by the board in its approval of Appeal 2012-318, which would be 8 years ago, basically. And that application and approval was made by and given to the same applicant as you're going to hear from today. And approval of multifamily use as 2 dwelling units that was originally approved in 1969. So there is a long history of this property being approved for 2-family unit use. We do recognize that. However, the issue at question is this property has been vacant and in fact was subject to a vacant house notice at the time of the original appeal heard by the board in 2012 and has not been issued a use and occupancy permit for 2 units because the owner did not complete required improvements to the property, bring it up to habitable condition. That basically is the reason for the concern of the community.
Thank you. Mr. Chairman, I cannot find Mr. Walcott here. What I'm going to do real quick is unmute our callers and see if he called in. Otherwise, we'll have to find out what happened to Mr. Walcott.
Okay, let me ask Mr. French. Again, I apologize. My audio is going in and out this whole hearing, but I did not hear what recommendation, if any, is being put forth by planning on this particular property.
All right. The planning department is recommending a disapproval of this application because proposed use is essentially inconsistent with the community plan for the area, the adopted plan adopted by the Planning Commission in 2006. That's the fundamental issue when you get down to it. And the fact, the aggravating factor is that it appears this particular property owner received approval from the board in 2012 to have 2 units in the building and then has not actually gotten the building into habitable condition and gotten those units occupied since that time and has filed this new application with the board as a result of that.
Thank you, Mr. French.
You're welcome.
Okay, I guess, so he's not posting. We can't find him at this point.
That's correct. I'm going to unmute some callers real quick and see if he's called in, and if not, we'll have to postpone this case. So let me unmute. I'm unmuting our callers. If a caller is Mr. Walcott or is speaking on behalf of Mr. Walcott for 2763 Alameda, please let me know. So no one is making any noise, so I'm presuming that Mr. Walcott is not available. And Mr. Chairman, I believe that's our docket.
Okay, do we need to go back at any other, one more time to check 2020-74, 1001 North Broadway?
You can certainly call it. I have not seen Mr. Smith pop back up in my screen.
All right. I'll just call it for the record, 2020-74, 1001 North Broadway, Wally Smith, to use first floor as clothing store. We've called this case several times earlier today with no response.
And Mr. Chairman, I'm going to unmute Mr. Popescu real quick. Stephen Popescu, are you there, sir? All right. I was just seeing if he was representing someone on the docket today, but I guess he's just observing. Other than that, I do not see anyone for that case, Mr. Chairman, 2020-74.
Okay.
How about 2020-77?
Yeah, I guess I'll recall that one just for the record. 2020-77, 2511 Chelsea Terrace, Lisa Tate, to use first floor as 15 child daycare center.
And again, I will unmute our callers and see if any of our callers are Miss Tate, Miss Lisa Tate, or speaking on behalf of Miss Tate. Anyone there? And that's no response, Mr. Chairman.
Okay. Well, we can figure out procedurally how we deal with that in our deliberation. So I believe that is the docket.
Yes, sir.
All right. We will turn the regular docket to conduct deliberations.